Morning, Judge.
Hey, Mr. Lee, how are you?
Good.
I'll admit everybody at 8:59.
Okie doke. I'm ready for the show.
Yeah, thanks for all the work.
No problem at all. This has been the most challenging one of these cases I've taken for the PRC.
Yeah, no, this is the newspapers described this case as a monster. And that's exactly what it is. Not our words, their words.
Every single day.
Yeah. Well, it's almost over.
Yes, sir.
All right, here they come.
Morning, Mr. Lee.
Morning, Mr. Marks.
Is my microphone all right?
As long as your face is right there when you're back up, you're a little canny.
Okay. I'll see if
I know it's difficult.
yeah. It's the hardest part of this lawyering.
It's a new age, my friend. I'm ready when you are, Judge.
Thank you, Mr. Lee. Good morning.
Good
Morning, colleagues. All right, let's go on the record. Welcome all to this 11th day of rate case hearings in the P&M rate case. We are at the end of off the record, at the end of the hearing last night, we reshuffled the witness order to attempt to potentially end the hearing a little bit sooner than next Tuesday, the 26th of September. And with that in mind, we talked about potentially stipulating the admission of certain witness testimony. In particular, I believe it was Walmart witness Steve Chris. And I see Ms. Barrett is here this morning. Ms. Barrett,
Yes, sir.
would you be agreeable to that process?
Yeah, Walmart has no problem with that.
Okay, thank you. Is there any objection to waiving the appearance of Steve Chris and admitting his testimony by stipulation?
No, Your Honor.
Hearing no objection, I believe it's Walmart Exhibit 1. Is that right, Ms. Barrett?
That's correct.
Walmart Exhibit 1 is admitted. Thank you very much, Ms. Barrett.
Thank you.
And I see that we have Mr. Marks here this morning. Good morning, Mr. Marks. We were trying to get a hold of you last night, or at least Ms. Zanazi was on our behalf. Is it possible? Well, first off, good morning, sir.
Good morning, Mr. Medeiros. And Ms. Nanazi was a good agent for you. She did get,
Yes.
she tried repeatedly and finally got through to me. And I am.
And I was wondering, we were wondering whether Dr. Fisher might be able to testify on Monday, the 25th.
Mr. Medeiros, that's not going to be possible, but I am confirming with him, but I think Friday will work. Monday he's not available, and I'm also not available. So Friday, and if not, I know he's available this afternoon. If I find out, find out unexpectedly that he's not available tomorrow, we could put him on the end of today.
Well, we have a long roster today. We could switch that around because, so let's let's see where we are toward later in the day, because there is some significant cross-examination for Dr. Fisher, I believe. Well, there's only 30 minutes reserved with by the Water Authority and PNM with Dr. Fisher. So it may be better to attempt to get him on this afternoon if possible. We'll see where we are. But I thank you for your flexibility and thank Dr. Fisher on my behalf as well.
Thank you, and I'll confer with him, and I'll let you know as soon as I know, which should be before noon.
Thank you. Well, in short, Dr. Fisher will be either testifying this afternoon or sometime tomorrow at this stage.
Thank you.
Thank you. Is there anything else to address before we move to Mr. Meyer, to New Mexico area's next witness? Yes, Mr. Gould.
Yes, looking at the exhibits that PNM provided for us overnight yesterday, it looks like most of them are going to be used to cross-examine witness Christopher Walters. And I want your advice on what would be the most efficient and least disruptive way to lodge our objection to the use of any or all of those late filed exhibits. I would say proposed exhibits.
I'd prefer at this point to take the exhibits as they are attempted to be used.
Okay. Okay. Thank you.
I appreciate the sentiment. Hearing Examiner Ryan.
Yeah, I just want to say one thing, and I think it's important to note for the record. In other proceedings, Ms. Beatles and Western Resource Advocates made a persuasive argument that, requiring free admission of cross exhibits while, conducive to the efficient conduct of a hearing also disadvantages parties in ways that could be problematic. And I'm not suggesting that that is the answer to the present objection lodged, but I would point out that I understand Ms. Beatles and Western Resource Advocates' points well, and a party may want to have legitimate cross on something that could really change the testimony of a witness. So I just float in that for purposes of the record.
Yeah, and that is not, thank you, Mr. Ryan. That's not the nature of my objection. My nature of my objection is not that broad. It'll be much more specific, and I'll defer those objections to when and if PNM attempts to use them in the cross of Mr. Walters or Mr. Myers. Thank you. Appreciate it. And with that, we're ready to move on. Yes,
right.
Thank you.
Well, this issue is something that Hearing Examiner Ryan and I have discussed at length. On the one hand, this is not trial by surprise. We rely heavily on document and pre-filed testimony, and then cross-examination and hearing examiner and commission examination on the documents, on the pre-filed testimony, and on the exhibits. That's what's been going on throughout this rate case proceeding, for those of you watching on YouTube. But on the other hand, it is still a trial type setting. So there's a balance that we have to attempt to achieve. And that's what I've been struggling to do with these PNM exhibits 63 through 70, and why I made the ruling I did on cross-examination exhibits at the August 31 pre-hearing conference, is to try to achieve some sort of balance between everybody being on the same page. There are no big surprises. On the other hand, the parties need to be able to make their cases in a trial type setting. So with that observation, I'll move to Mr. Herman. Good morning, Mr. Herman.
Good morning, Mr. Examiner. On an alternate topic, there's a technical issue with the live stream that I wanted to bring to your attention from yesterday. Apparently the live stream never shut down. So it's unavailable to some of my witnesses who have been trying to watch it, and it might still be going, so that might be something IT would like to look into. And
Yes, hopefully Ms. Kippenbrock is listening to this, or somebody from IT is listening to this, to check into the YouTube stream from yesterday.
And then just on a personal note, I'm going to need a periodic excusal this afternoon due to childcare commitments. And going back to our discussion about Mr. Fisher, after conversing with Mr. Harris, we can waive that cross-examination. So, and if at any other time I'm unresponsive during some of the later testimonies this afternoon, I will waive that cross-examination as well.
Thank you, Mr. Herman. So in specific, who was that you waived cross-examination for?
Mr. Fisher.
Oh, okay, Dr. Fisher.
I'm sorry, Dr. Fisher.
Okay. No, I wasn't criticizing you. It's funny the way I hear things. So I didn't hear
I
the
made
doctor
same
first.
mistake with Dr. Pitts, so I try to respect the titles.
Well, and you are excused for that very happy task of taking care of your child.
Thank you.
So, yeah, that's Dr. Fisher waiver. Okay, is there anything else? Mr. Nazi, good morning.
Good morning. I have a board meeting between 1:30 and 2:30 this afternoon, so I'd like to be excused. And obviously, if anything happens during that time and I miss it, I understand that I've waived it.
Thank you. You're excused.
Thank you.
Anything else?
And Mr. Herman, I might have hit the I lowered your hand, but I think I hit the ask to unmute button. So no one's asking you for anything.
Thank you.
The hand thing, I've been paying attention to the screen carefully, and it's good to make it go away once we're done, you know?
So let's see how far we make it this morning with the witnesses. We may ask Dr. Fisher to testify this afternoon. That would probably be before we get to the staff witnesses. The idea being that the staff witnesses, presumably except for Ms. Ramey, who can't testify on Friday, would be available tomorrow. So if there's nothing else, I'd like to move to the continuation of the presentation of evidence. And that means that New Mexico area should please call its next witness.
Thank you, Mr. Medeiros. Mr. Meyer, would you introduce yourself for the record?
Sure. My name is Greg Meyer, and I work for Brubaker and Associates.
Could the witness be sworn in, please?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now opinions be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Mr. Meyer, what is your job title and your employer's address at Brubaker and Associates?
I'm a principal with the firm, and our business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017.
Mr. Meyer, you have in front of you what has been marked for identification as NM Area Exhibit 9, do you not?
I do.
Is that your direct testimony and exhibits which were filed in this matter on June 23, 2023?
Yes, they are.
And would you look at that document and make sure that it is an accurate copy of your direct testimony?
The copy I have is accurate.
And do you have any corrections to make to that direct testimony?
No, I do not.
If you were asked the same questions today, would your answers be the same?
They would.
And are those answers true and correct to the best of your knowledge and ability?
They are.
Mr. Hearing Examiner, I would move for the admission of NM Area Exhibit 9.
Is there any objection? Hearing none, New Mexico area Exhibit 9 is admitted.
pass the witness for cross-examination.
Thank you, sir. Morning, Ms. Twilliger.
Good morning, hearing examiner.
We have you set for 30 minutes with Mr. Meyer. Is that correct?
Yes, thank you.
Okay, please proceed.
Good morning, Mr. Meyer.
Good morning.
My name is Debria Twilliger. I'm representing PNM. So I want to start with your testimony regarding PNM's forecast of its projected sales level. You disagreed with PNM's projected sales forecast, is that right?
That's correct. The
Okay.
usage per customer.
All right. And at page 8 of your testimony, which is NMRA Exhibit 9, I believe, you have the table GRM3 there. And it reveals how unreasonable, I'm quoting you here. It reveals how unreasonable the sales proposed by PNM
It
are.
reveals, can you slow down a little bit?
Sorry, Mr. Lee. Reveals how unreasonable the sales proposed by PNM are when comparing proposed sales to historic sales level.
That's my testimony, yes.
Okay. And if you look at table GRM3, it shows historic usage per customer. Isn't that right?
That's correct.
And you ultimately recommend using a 2-year average of usage per customer for the years 2021 and 2022. Is that right?
That's correct.
Okay. And so you use the historic relationship of usage per customer to make your conclusions that PNM has overstated its sales forecast. Is that correct?
The sales forecast that PNM projected in the test year is understated when looking at the historical usage per customer.
Specifically 2021 and 2022, right?
Well, I think you can look at the fact that the usage per customer that PNM is proposing is less than every year in the table. So I used the 2 years, but when you look at it holistically against all the table figures, it's less than all those usage per customers for those years.
And can you point me to anywhere in your testimony where you address reduced sales forecast because of increased PV adoption?
It's not, it's inherent in the 2-year average that I used.
And are you aware that there's a projected to be an additional 88 megawatts of solar capacity in the 2.5-year period between the base period and the test period?
That's what I believe. Check. That's the testimony of your witness, Mr. McMenamin says, yes.
Dr.
Go
ahead.
McMenamin, I'm sorry. Yes, I read that.
Okay, and so you did not factor in at all the projected change in the sales forecast for using your 2-year average of 2021 and 2022. You did not look at the projected PV penetration for those for that time period between the base period and test period to arrive at your conclusion. Is that right?
I believe that the 2-year average reflects some PV interactions already, and I haven't seen convincing evidence that the PV enhancements or greater PV exposure would change these numbers. So the PV has been around, and it hasn't affected the usage per customers that are in GMR3.
So did you provide any or did you do any analysis to determine that PV or do you know that PV penetration, particularly behind the meter residential PV penetration, is increasing?
Well, I think it's increasing. I think it's either going to, obviously, if you add more PV to solar rooftop or to rooftops, you will get an increased penetration. But there are offsets for that I don't know that were properly measured as well.
All right, I want to discuss your inflation adjustment next, which is your table GMR4. And I'd like to do a hypothetical exercise with you on this table GMR4 before we actually talk about the base period and test period. So I'm just going to start, if we had $100 cost in 2020, so before this table sort of picks up, that 4.69% inflation in 2021 would cause that $100 to go up to like $104.69. Is that right?
I think your calculation would be accurate, yes.
Okay. And then if we take the 2022 inflation on top of that $104.69, we would go up to $111.08. Is that right?
Using those figures, I think that's approximately correct, yes.
Okay. And then the 2022 inflation would cause that $111.08 to rise to approximately $114.52. Is that right?
I think you said 2022. I think you might have meant 2023.
If I did say 2022, I meant 2023.
So
But-
you're at about 115.
Okay, yeah, that's about right. And then that 2024 inflation would cause that 115 approximately to go up to $117.25. Is that right?
Alex, that seems about in the right ballpark, yes.
So inflation pancakes, isn't that right? It pancakes cost.
It does.
Okay. And so PNM's base period ended on June 30th, 2022, didn't it?
Yes, ma'am. Yes.
So if we just look at your table for, I guess we don't look at your table. Let's just think about the base period. Any cost embedded in the base period did not account for the full inflationary effect of 2022. Is that right?
Your base period would have not accounted for the second half of any inflationary impacts that would have affected specifically PNM.
Okay, and in fact, you acknowledge that at page 13, line 14 of your testimony, where you specifically say that therefore some expenses, those expenses already reflect the effects of inflation for 2021 and some of 2022, right?
That's correct.
And do you know that the full impact of inflation for all of 2022 was actually in the neighborhood of over 8%?
I saw that. I wasn't able to verify where you got the 8% though. But you're not dealing specifically with PNM. And Mr. Sanders in his direct testimony, I wouldn't say boasted, but talked about how PNM in the past has been able to achieve cost savings or control costs that have been below the CPI. So
CPI.
CPI, I'm sorry.
Thank you.
So, you have a unique situation in that in one instance, you want to bolster your image or your place by saying that you've controlled costs to 1.5% for a 10-year period, which has been, that's your inflation at or below the CPI. And yet when it comes to actually reflecting those costs in a rate case, you want to just use the CPI inflators. And there's no recognition for that efficiencies that you've acclaimed over the last 10 years. It just stops. And I just don't think that is an appropriate measurement of the inflation.
But Mr. Meyer, even you acknowledge that inflation has impacted utilities in ways that might not be able to be fully controlled by cost, right? You allow for the effects of inflation for 2023 and 2024 to be
Begrudgingly. I'm sorry. Go ahead, ma'am. I'm sorry.
Go ahead.
I say I did it begrudgingly because I believe that is not a known and measurable factor, but I did it. I did recognize it. But I acknowledge that you should get the inflation that I listed on GRM4 of 3.1 and 2.4, but also the inflation from what you argue that I've missed 2022. I believe that what I've given you is a conservative inflation indicator because of the fact that you've historically beat it. And yet you don't want to reflect any productivity savings in those expenses. And I think that's just improper.
But you recognize that your testimony did not, from the point of view of the base period, you did not, and given that inflation pancakes, you did not recognize the second half of 2022 in terms of the inflation that PNM, in terms of the inflation that PNM will experience in the test period.
And I disagree with that. I disagree with that characterization completely.
Okay. And because you only recognize inflation for 2023 and 2024, you feel like you've done enough in terms of inflation. Is that your testimony?
Well, I think what you have to say is that the amount of inflationary expenses that we've reflected in the test year 2024 by using the 2023 and 2024 inflation rates is a very accurate and if not a conservative estimate of what the inflation impacts will be on your expenses in the test year.
But since inflation pancakes in our exercise, we know that you're missing costs from the second half of 2022.
But the flip side of that is where is the inherent efficiencies that you've recognized in your expense controls for the past 10 years that you don't recognize now when setting a level of expense? You give nothing.
Isn't that inherent efficiencies in fact recognized in the base period dollars? It's already recognized in the base period dollars.
You claimed in Mr. Sanders' testimony that every year for 10 years, you exceeded the efficiencies of inflation. And all I'm saying is that our adjustment for inflation properly recognizes the expenses that will be in effect in the test year.
And that,
Mr. Welliger, can I just interrupt 1 second? Can you just clarify for me, you and Mr. Meyer seem to have an agreement about what it means for inflation to pancake, but for the purpose of the record, can you describe, and perhaps you can ask Mr. Myers what exactly that means? I'm following your discussion, but I want to make sure that I fully understand what you're saying to each other.
well, go ahead, Mr. Meyer. If I disagree with the characterization, maybe I'll ask you questions. I tried to do that exercise.
Yeah.
Hearing examiner Ryan to demonstrate it, but maybe it wasn't super clear.
So
Well,
it tends to, are you going to
go ahead.
talk about stacking?
I mean, pancaking and stacking are synonymous in my mind. So all it means in my mind is that as inflation goes from one year to the next, not only is the base amount inflated, but it's are subject to that inflation, but also the inflation impacts from a previous period. But in this instance, what we've done is we've just recognized the 2023 and 2024 inflation estimates, but we believe that will more properly reflect the costs in 2024
Thank
from
you.
inflation.
Let me ask you this. If the base period had ended at the end of 2022, and assuming Mr. Sanders' testimony, I don't know if you have reason to doubt it, that the inflation from the compound annual growth rate, which is a published number for 2022, was in fact 8.1%. Our PNM's base period dollar or base period starting point would have been higher because of that inflation. Isn't that right?
Not by the 8.1. Because and here's my reasoning. You've testified that you can beat inflation. You've done it for 10 years. And so I'm not going to accept that if you extended the base period to 2022, that those expenses would have been inflated by 8.1%, because your own witnesses have told this commission that they can do better in cost control than the CPI.
Okay, and then let's get to that point, because that's the question I was going to ask you before the hearing examiner asked his question. Those benefits that the company has, that you're touting on behalf of the company, those are in fact already reflected in the base period dollars, right?
Well, correct. And you enjoyed, if if rates were set in the prior case based off the same methodology that you're proposing here, you would have enjoyed enhanced profits because your cost control or your cost efficiencies were greater than CPI. And I'm not willing to build in enhanced profits in this rate case for overestimating inflation costs.
But you characterize them in enhanced profits when they in fact are inflation that the nation as a whole is experiencing. Is that right?
No, they are enhanced profits. There is no doubt about it. If we put in 3 and 4% and you control your cost to 2%, there's a 2% enhanced profit that has been built into rates that you were able to achieve through cost efficiencies. And I'm just trying to mirror and to closely reflect that impact.
Okay, let's talk about your O&M labor changes. I'm going to go to GRM 5.
Okay.
You base your recommendation of a 1.8% escalation factor on historical O&M labor expenses. Isn't that right?
That's correct.
And if you look at that 2022% changed, do you have the FERC Form 1s that you relied upon to source the labor expense in GRM 5?
I do.
So let's just go to the one I have is for fourth quarter 2022. I'm on the page you referenced, page 354.
Mr. Harrington, before we go ahead, is this document anywhere in the record?
It's
I understand.
It's cited by Mr. Meyer.
I understand. Did PNM include it in any of its schedules? I just wanted to know if it was in the record.
No, but it's cited by
Okay.
your witness.
Yes, thank you.
So for the if we look at that table for that 123,979,391, that's for 2022. You see that? It's
I do.
It's on page 354 of FERC Form 1, line 28 for that FERC Form 1 for the last quarter of 2022, right?
I don't have the exact same reference as you do. I have the 123,979 though.
Okay. And that number encompasses a production value for direct payroll distribution, does it not?
Yes, ma'am.
Okay, and that, at least in what I have, is 32,888,965.
That's what I have as well.
Does that 32,888,965 account for attrition at the San Juan generating station?
I would not be able to tell you that.
Okay. So you don't know if in making your recommendation for O&M labor charges, you don't know if the San Juan attrition was already accounted for.
Well, I know that in the rebuttal testimony, I believe Ms. Pino, and I can't recall off the top of my head who the other witness was, mentions that I did not reflect the effects of the San Juan employees leaving. Now, the San Juan employees leaving, according to the testimony, the company testimony was towards the end of 2022. So this figure that you have here, although it may have some impact, probably didn't reflect the full impact of the San Juan employees leaving at 2022.
What the 32,888,965, is that the figure you just referred to, Mr. Meyer?
That's the production figure, Mr. Medeiros. That's what they claim as labor expense for the production function.
That's not reflect. You go ahead. I'm sorry.
That just is the 12 months of labor expense charged to the production function.
And that's reflected in a FERC account, right? It's not reflected in your testimony anywhere.
No, that specific production is a component of what Ms. Williker provided in the 123.
Okay.
Now,
but you agree to that figure.
it's
that it's accurate.
It's included in my figure, yes, but one has
Okay.
to recognize also, Mr. Maderas, that when positions are eliminated at utility, typically, and it's common practice for the utility to search for those positions to be filled within the organization and other areas. I'm aware of a electric utility in Missouri where there's a clipboard in the hallway that shows vacant positions, and so employees are there's an attempt on the company's part to reassign those employees to other functions within the utility operations. That's just common practice. So to the extent that San Juan employees were not needed, obviously, to run a retired plant, I believe there would be an effort on behalf of P&M to relocate those, or they're at least offered jobs in other areas of the utility that they can choose to take.
So let me ask you this, Mr. Meyer, or sorry, were you done hearing examiner?
Yes, thank you.
If San Juan units 1 and 4, well, San Juan units 2 and 3 closed in 2017. Is that right? Do you know?
That's my understanding,
Okay.
yes.
And San Juan units 1 and 4 closed in 2022. Is that right?
At different timeframes, I believe.
So if P&M reported on its FERC Form 1 for 2022, when the plants were still open, and even for 2021, when the plants were still open, if they reported the production amount related to O&M, direct payroll distribution, on their FERC Form 1s, you would agree that figure does not account for attrition at the San Juan units.
Well, 2022s would have some attrition in it from San Juan. I don't know that the full amount of the attrition from San Juan would be in there. But again, to measure the attrition from the San Juan retirement, you have to track those employees to make sure that they weren't assigned to other operations within the utility. It's just not, and that was brought up in your testimony, is that those employees will no longer be working for the plant. And I don't disagree, because I think it'd be imprudent to have employees sitting in an idle plant. But those employees may actually been transferred to other operations within P&M, which is common practice.
And you know that the San Juan costs were removed from base rates in this case, isn't that right?
On a going forward basis, yes, but they're
So
they're still in rates right now. But I think that was a settled issue, if I understand correctly.
but for the test period, they've been removed from rates, right?
The 2024 test period?
Yes, they've been
Yes,
removed.
because that's what you want to, that's going to be the basis for establishing rates in this case. So I would hope that they're out of there.
Okay.
I would expect them to be out of there. Let's put it
So
that way.
if you did not account for natural attrition in your labor O&M, and San Juan has been removed from rates, that natural occurrence of use, you note that this, San Juan employees move around, you would essentially be double counting the effect of San Juan in terms of both lowering your O&M labor expense without accounting for San Juan, while at the same time P&M has removed this from rates. Is that right?
No, there's no double count. None whatsoever.
All right, let's talk about your recommendation regarding account 391.3 related to depreciation rates. You make a recommendation regarding this account, right?
I do. I recommend that the depreciation rate should not be changed.
But you state, you think that there is mainframe equipment in that account, is that right?
Yes, that was my direct position.
That was the basis of your testimony.
Yes. Yes, subsequent, I have other arguments why that rate should not be changed.
But you agree that there is no longer mainframe equipment. You understand, I assume, given the NM area discovery attached to Mr. Watson's rebuttal, that their PNM does not have any mainframe equipment.
Yeah, that's the claim that they made. There's still significant amounts of investment that have lived beyond the proposed depreciation rate of PNM in this case.
But
The
that would
5
be
years.
new, but that would be new testimony, wouldn't it?
Well, I just looked at it and I think it's an exhibit in the case, the NM area 5-4.
But you based your recommendation on the fact that there was mainframe equipment in that account, right?
That was one of the reasons, is that I believe that there's investments in that account that are living longer than 5 years. I classified those as mainframes. That was probably a poor choice of words, but your account has 30% of your account is over 5 years or older, and that doesn't even reflect all the assets that I believe are in that account. So at this point, I don't think moving to 5 years is the appropriate adjustment.
You understand that this account 391.3 is subject to accounting release 15. Is that right?
I'm not that familiar with accounting release 15. It's my understanding that this account is treated as an amortization account where the assets are amortized over a certain amount of years.
So you're not aware, or you don't know how accounting release 15 works for these types of accounts, that it retires assets when they reach the age of their average service life. You don't know that?
Well, I think I just told you that this account is treated as an amortization account that is amortized over a certain period of time. In your previous case, it was set up for 10 years. You're asking to move it to 5.
All right, that's all my questions. Thank you very much.
Thank you, Ms. Twilliger. Mr. Herman,
Questions, Mr. Examiner?
I'm sorry.
No questions, thank you.
Okay, thank you. Examiner Ryan, we probably don't have commissioners today as an open meeting, but.
No, yeah,
do-
no
do-
one's here.
Do you have
Just one-
questions for Mr.?
Just one follow-up that Mr. Welliger got into is the subject of my one question that I wanted to ask, which was so mainframe computer investments. What do you believe is there, and why do you believe it?
If you look at NM area 5-4, it's a response, and I believe this was put in the record in cross of Mr. Watson. The account includes, as far as what Mr. Watson included in his study, the account includes approximately $52.5 million of investment with a cutoff of 2013. So from 2013 to 2021, there is approximately $52.5 million of investment in this account. 30% of that investment, and this is with this cutoff, and speaking with my co-worker, Brian Andrews, who's a national depreciation expert, he says this account was probably cut off to reflect only 7 years of the asset's life. The 30% of the assets listed in NM Area 4 have a life that's been longer than 5 years. And so it's my contention that if you looked at the total asset values in 391.3, these assets are living longer than 5 years. And I would note that it's probably better in the future to look at all the assets that are contained in these amortization accounts and see exactly, that should be the gauge whether the amortization period is adequately long enough or short enough to make sure that there's proper collection of those costs compared to its actual usage or actual life. Moving to 5 years in this instance would be too short.
So, but mainframe computer investments versus other computer investments, I'm in my mind imagining like giant servers or something.
There are servers, and that's I'm sorry, Ms. Ryan, if I interrupted you.
No, you didn't. That was
There
fine.
are servers in M area 5-4 that are listed as servers. There's stuff in here called computer hardware that have, you know, upwards of $1 million per investment. So yes, I think I do believe there is investment in here in 391.3 that will exceed a 5-year life. Well, we know it. I mean, we know that 30% of these assets that are currently listed have exceeded 5 years of their life. So that should be a signal that moving to 5 is too short.
So just so I'm clear on the subject, what you're saying is by looking at, and if you could correct me if I misstate this, just again, trying to be clear, by examining the life of assets that aren't necessarily described, you can correctly deduce that these are mainframe investments versus other types of computer investments. Is that correct or incorrect?
I personally can't go through because I'm just looking at a piece of paper. I think you'd have to look at the actual assets that back up these figures. But there are mentions, as you mentioned, there are notations of server, computer hardware, and in both of these instances, these assets have lasted or lived longer than 5 years.
Okay, that was all. Thank you, Mr. Meyer.
Thank you.
Any redirect?
Just a couple of areas, but before we start, just to keep the record clear, Mr. Meyer, you used an acronym CPI. I think everybody understands that, but what did you mean by that acronym?
Consumer Price Index.
And what is the Consumer Price Index? If you can tell us, put it on the record.
It's just a measurement of the increases or the inflationary increases in costs per year.
And Mr. Hearing Examiners, just for the clarity of the record, the interrogatory response to 5-4 was put on the record, I believe, as NM Area Cross Exhibit 42.
Thank you.
Mr. Meyer, you recall the questions that Ms. Terwilliger had for you on projected sales revenues?
Yes.
And in response to one of her questions, you stated that you did not believe that PNM had adequately adjusted the figures on PV penetration for other factors. Could you explain what you meant by that response?
Sure. If I read in reviewing in the testimony of Dr. McMiniman on page 26 of his direct testimony, he provides a chart that shows the impacts. I think that Ms. Williker was describing in her cross of me. So for the base period to the test period, it shows that PV and energy efficiency are probably the greatest, or they are the only two factors that drive down usage per customer. And what was interesting to me is that they also agreed to monitor or to model EV, and EV electric vehicles only had a very minimal impact between the base period and the test period, where PV and energy efficiency were both dramatically higher. In fact, the effects of PV and energy efficiency when combined against the effects of electric vehicles, those two factors alone were 20 times greater than the electric vehicle impact. And I just find that very hard to believe, especially when you look at also that that PV and energy efficiency have been around, and it hasn't impacted the usage per customers that we've seen historically. There's just a mismatch in the variables, and I think they've overstated the impact from PV and EE.
Moving to the questions that Mr. Williger asked you about your recommendation that the depreciation rate for a FERC account 391.37, in response to one of her questions about your position that the current depreciation rate should not be adjusted downward or adjusted to 5 years, you stated that there are other arguments why depreciation rate should not be changed, why this depreciation rate should not be changed. Can you augment what you meant by that statement?
Yeah, I think as I explained or tried to explain to Ms. Williker, I did use the mainframe argument in my direct testimony, but when you look at the exhibit that was provided by MN area of the cross and Mr. Watson, it's obvious that the assets that are comprised of the account 391.3 have a much longer life than the 5 years that's being proposed by Mr. Watson. And just so we're clear, the cutoff that's contained in that exhibit is what he originally thought was the current amortization period, which was 7 years, and then he found that he had misstated that, and it should be 10. So there's actually assets. It's in our opinion that there's actually assets that are not included in that cross exhibit that are still in service from years 7 and beyond that should be reflected. And that's why we don't believe at this point that the amortization period for this account should be changed from 10 years, which is what it currently is.
And this is my last question. Is there any place in your testimony where you show the total impact on PNM's proposed revenue requirement of changing the depreciation in this account to 5 years?
Changing it to,
Yeah, if it is changed, if it's kept the same, I guess what I'm asking is what's the difference in the revenue requirement between keeping it the same and changing it to 5 years? Did you address that any place in your testimony?
yes, page 5 of my direct, line 7 of GRM1, $7.5 million.
Those are all my questions, Mr. Examiner. Thank you.
Thank you, Mr. Gould. Anything further, Hearing Examiner Ryan?
No, thank you.
Okay. Mr. Meyer, it's always a pleasure to have your testimony. It's good to see you, sir.
Nice to see you.
Your excuse, sir. Thank you.
Thank you.
New Mexico area, would you please call your last but not least witness?
I hope he's not least. Yes, Anameria calls to the stand Christopher C. Walters. Mr. Walters, could you introduce yourself and state who your employer is?
Sure. Can you guys hear me okay?
We can hear you great. Thank you.
Great. Hi, my name's Christopher C. Walters, and I work for the firm Brubaker and Associates.
Mr. Lee, would you swear in the witness, please?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, sir.
And Mr. Walters, would you state for the record what your position is at Brubaker and Associates and your business address, please?
Yes, I am an associate with the firm. Our business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017.
And Mr. Walters, you have in front of you a document which has been labeled for identification as Anameria Exhibit 5, which is the corrected direct testimony of Christopher Walters. Do you see that?
Yes, I do.
And this is what you have in front of you. It is a correct copy of that testimony?
Yes, to the best of my knowledge.
And do you have any additional corrections beyond those that are included in this document?
No, I do not.
And if you were asked the same questions today, would your responses be the same?
Yes, they would.
And are those responses true and correct to the best of your knowledge and ability?
Yes, they are.
Mr. Hearing Examiner, we would ask for the admission of Anameria Exhibit 5 into the record.
Is there any objection? Hearing none, New Mexico Area Exhibit 5 is admitted.
And then would you turn to the second document that you have in front of you, which has been marked for identification as Anameria Exhibit number 6.
I'm there.
And that is the rebuttal testimony of Christopher C. Walters, excuse me, which was filed by you in this case on July 28th, 2023.
Yes, it is.
And have you reviewed that document and made sure that it's a correct copy of your rebuttal?
Yes, it is.
And if you were asked these same questions today, would your responses be the same?
Yes, they would.
And are those responses true and correct to the best of your knowledge and belief?
Yes, they are.
Mr. Hearing Examiner, we would ask for the admission of Anameria Exhibit 6 into the record.
Any objection? Hearing none, NM Area Exhibit 6 is admitted.
We would pass the witness for cross.
Thank you, Mr. Gould. Good morning, Mr. Alvidrez.
Good morning, Mr. Hearing Examiner. Can everyone hear me all right?
Yes, sir.
Yes.
At least I can. 45 minutes, is that right?
Yes, it won't take near that long, but we'll.
That's fine.
Good morning, Mr. Walters. My name is Rick Alvidrez, and I'm one of the attorneys representing PNM in this matter. I don't think we've met before, but it's a pleasure.
Nice meeting you.
I've got a couple questions, just some background questions. As I read your resume, you've got a bachelor's degree in business economics from Southern Illinois University. Is that correct?
It's a Bachelor of Science in Business Economics and Finance. Yes.
Okay. And you have an MBA from Lindenwood University?
Yes.
Where is Lindenwood University?
Sure. It's based in St. Charles, Missouri, which is just northwest of St. Louis.
Okay, so it's very close to where you're at now. Is that right?
Yes.
And you've been with Brubaker and Associates since 2011. Is that correct?
Since January 17th, 2011.
Okay. And you indicated your job title is associate. Is that correct?
Yes.
And what does the title associate mean in terms of the hierarchy of employment positions at Brubaker?
Sure. So there are several levels of within our firm. If you would like for me to go through them all, I can.
Well,
so I'll work from top down. That'll be quicker.
Okay.
So working from top down, there's managing principal, who are the 4 equity owners of the firm. There are principals and then associates. And then below that, there are several layers as well.
And I looked at your resume. It looked like you worked your way up from near the bottom layer, perhaps. Is that correct?
From the analytical side, yes.
Okay. And You provide a list of states in which you've testified on pages 2 and 3 of Appendix A to your direct testimony. Is that correct?
Let me get there if you don't mind.
No, please do. And I'm really talking about the bottom of page 2, going over to the top of page 3 of your Appendix A.
Yes, that is correct.
And on page 3, line 4, you indicated that you've provided an affidavit before the FERC. Is that correct?
Yes.
And what did that affidavit involve?
I've actually, I guess that could be updated because I filed an affidavit on behalf of a transmission owner proposing a recommended return on equity for the transmission owner on their behalf. And then I also filed a case, it was a Tucson Electric Power FERC OATT rate case a year or two ago.
Was that an
for-
affidavit? I'm sorry, go ahead.
No, you're fine. I honestly don't know if it's considered testimony or affidavit what I filed a year or two ago. But I filed on behalf of Freeport McMoran, I believe was the client. And Mr. McKenzie was ironically the witness for Tucson.
Okay. And is it typical that you testify on behalf of large consumers of electricity?
No.
Do you testify on behalf of utility companies?
I have. I mean, like I just said, I testified on behalf of the transmission owner, recommending, making a recommendation for their own ROE in the FERC proceeding. That was my first FERC affidavit. And then a lot of times I filed on behalf of attorneys general, utility commission staff, federal executive agencies, citizens utility boards, large industrial users, and the like.
So is it fair to say the majority of your testimony is for consumers, the consumer side of the utility regulatory regime?
Yes, I would agree with that.
Okay. On page 27, beginning at line 2 of your direct testimony, I'll give you a moment to get there.
I'm there.
You describe what a utility's cost of common equity is that correct?
Yes.
And that cost is typically expressed as a percentage, a return on common equity or ROE, is that right?
Yes.
And you would agree that an ROE is a necessary cost of doing business for a regulated utility, right?
Yes, I would agree with that.
And you would also agree that an ROE does not guarantee that a utility will make a profit at the approved ROE, correct?
Correct. They are, in theory, they should be provided a reasonable opportunity to earn their authorized return.
Okay. Are you aware that there is a limitation on PNM's ability to earn above its ROE by more of 50 basis points?
Yeah, I believe that was, yes, I'm aware of that.
And a utility's cost of capital is also comprised of interest on debt, right?
Yes, within the weighted average cost of capital calculation.
And to determine the weighted average cost of capital, you look at a utility's capital structure, which typically includes percentages of debt and equity, right?
Yes.
And in PNM's case, there's also a component of preferred stock.
Yes, I think it's a very minimal amount, but yes, it's in there.
Okay. And is preferred stock akin to debt in a way?
In a way, it's not contractually obligated dividend payments, but it's typically treated, well, for example, in the rating agencies, well, in the assessment of the financial well-being or the financial integrity of a company, S&P will consider preferred stock as a hybrid, and now assign it basically 50% weight and calculate it as part of their adjusted debt. So yeah, they give it at least some weighting as a treatment of debt.
All right. And what is PNM's currently approved ROE?
I believe it is 9.575.
Okay, and do you know when that ROE was approved last by the commission?
If I recall, it was, I think the first commission order came out around December 2017. I think
Okay,
there
and-
were one or two
I'm sorry.
iterations. There were one or two amendments to the order after that, though I don't recall exactly when they were filed or what they amended.
And you're recommending a reduction of PNM's current ROE to 9.55%, correct?
9.55% would be a reduction, correct? But it's based on my assessment of the company's cost of equity.
I understand. And it's also premised on a capital structure for PNM that is comprised of an equity ratio of 49.61%, which is based on PNM's last approved capital structure. Is that also correct?
In part, it's also their current actual capital structure, give or take some basis points.
So you're not aware that their actual current capital structure is in the neighborhood of 52%?
What I saw on what was reported on S&P Capital IQ yesterday, the 2023 last 12 months ending, it was around 49.6 or 7%.
And was that based on FERC filings?
As I don't recall if it was the FERC or the SEC filing.
Okay.
Yep.
But if PNM's proposed capital structure of 52% is approved, you recommend a further reduction of PNM's ROE to 9.2%. Is that correct?
No,
It's not.
no, that's an inaccurate assessment of my recommendation.
What is your recommendation
Sure.
concerning if PNM gets a capital structure which is comprised of 52% equity?
I would like to refer you to page 3,
Right.
lines 6 through 8. And I will read that into the record if you would like.
Well, it says, should the commission award PNM's its requested equity ratio, an ROE in the lower half of my range, i.e. 9.2% to 9.5% would be warranted.
It says i.e. 9.2% to 9.55% would be warranted. So an
Okay.
ROE at or above 9.2 to at or below 9.55. And then I further reiterated that position in my rebuttal testimony.
Okay, so what you're talking about is not 9.2, but somewhere between 9.2 and 9.55. Is that
Correct.
Okay.
I would still stay within my recommended reasonable range.
Okay. You submitted testimony in the Southwestern Public Service Company case 20-00238 UT, did you not?
I believe so, yes.
And in that case, you supported a capital structure for SPS as part of a settlement comprised of 54.72% equity and 45.28 long-term debt with an agreed ROE of 9.35%. Is that correct?
Objection, Your Honor. There's been no foundation that the recommendations made for an entirely different utility are at all relevant to the ROE for PNM. That's my first objection. My second objection is the testimony that's cited is cited in terms of testimony in support of an entire stipulation, not just the one number or the two numbers that Mr. Alvedras has pointed out. And so therefore it's an inaccurate, it's not an accurate and complete presentation of what Mr. Walters' testimony is in that case.
Objections noted by the hearing examiner. Mr. Walters, did you note your counsel's objections? Mr. Alvedras, go ahead. Overruled.
Okay, yes. Do you recall that that you supported a capital structure along the lines that I just outlined in the SPS case I referenced?
In the context of a negotiated settlement where parties given, there's a lot of give and take. I did support that recommendation
And
for that stipulated settlement.
okay, and if I could have you turn to table CCW2 on page 8
Of my direct in this case,
of your direct testimony. Yes, sir.
I'm there.
And that table is a presentation that you describe as trends in state authorized common equity ratios. Is that correct?
It is.
And that's for the electric utility industry.
Yes.
And if we look at the recent years, recent by my definition being 2021 through 2023, we're seeing average equity ratios above 51%, correct?
Yeah, there's something that needs to be noted here. As you will see in footnote 2, it excludes the reported equity ratios for 4 states. So I did not go back in and check the authorized equity ratio for the electric utilities of those 4 states because they report, they use a lot more capital components that would otherwise bias down the reported equity ratio in the rate making process. But they are based also on, inherent in that they are based on investor supplied equity ratios. And I know for a fact, Arkansas electric utilities are all between 45 and 47% during those times. So that the reported averages would be lower, but that's just for sake of that. I'd like to know that.
You made a conscious decision to exclude Arkansas, Florida, Indiana, and Michigan because they include non-investor capital, as your footnote there indicates, correct?
Yeah, correct. And I explain it elsewhere in there too why I did it, but you're right.
And in terms of the median, we're seeing approved equity ratios at or very near the 52% level, correct?
Yes.
So I'd like to have you turn to page 9 of your testimony.
I'm there.
And really it's pages 9 and 10. And there you talk about, among other things, that recent years have been record setting in terms of utility industrial capital investments. Isn't that correct?
Yes. And it's further depicted on page 11 in figure 2.
Right. And at lines 18 and 19, you indicate that the increase that we've been seeing in capital spending is anticipated to persist in 2024 and 2025, correct?
Are you on page 9? Or
I'm on page 9 at the very bottom. And it goes over to page 10 a bit.
Yes. Well, just so I'm clear, can you repeat what you paraphrased that to say?
Yes. What I was paraphrasing is that you indicate that this increase in capital spending is anticipated to persist through 2024 and 2025.
Yes.
And at page 10, beginning at lines 3, you indicate that utility capital spending is tied to such things as upgrading aging transmission and distribution. Is that correct?
It is there, yes. Just so we're clear, these are block quotes from an actual report. I'm not saying it. The report is directly quoted in these.
Okay.
So, but yes.
But you're presenting this as evidence for the commission to consider this
Oh,
report.
yeah. It was just more of a clarification that it was taken from the report.
A good clarification, and thank you for that. The report that you present also indicates that the spending is related to building new gas, solar, and wind generation. Isn't that also correct?
Yes.
And the deployment of new technologies such as smart grid systems.
Yes.
And you don't dispute the need for these expenditures by utilities, do you?
I have not taken issue with the need to invest in those technologies.
Do you understand that PNM is undergoing a transition in its generation portfolio to no and low carbon emitting resources and moving away from larger carbon emitting resources?
I would agree that virtually all vertically integrated utilities are going through some sort of transition to a cleaner energy generation portfolio.
And the types of investments that PNM is making are consistent with the types of utility capital investments that are described on pages 9 and 10 of your testimony. Isn't that correct?
I would say generally I would agree with that. I haven't taken a deep dive into each and every or compared and contrast the investments relative to the rest of the industry or even the proxy group. But
and the cost of these transitions are necessarily capital intensive, are they not?
the utility industry as a whole is a capital intensive industry. So most of their investments long lived capital investments are going to be relatively capital intensive.
Well, I understand that, but what you described in quoting the report is that we're in a period of particularly high levels of capital expenditures, correct, for the utility industry?
Yeah, but I mean, capital expenditures don't necessarily mean capital intensity. There's actual measures of ratios for capital, if you want to measure capital intensity. And I don't know that anyone's done that in this case, or at least I haven't seen. But generally speaking, yes, you're talking about elevated capital expenditures, not necessarily capital intensity.
Okay. So what you're talking about is record capital investments. That's what the report is talking about, right?
Yes.
And you would agree that it's important for PNM to be able to access the necessary capital in order to make the capital investments to affect the energy transition change that it's going through, correct?
Of course.
And that its ability to be able to access capital is dependent upon its financial strength. Is that also correct?
I would agree with that.
And would you also agree that it would be important for PNM to emerge from this rate case with sufficient financial strength to make the necessary ongoing capital investments?
And I would agree, but I don't have any reason to believe that my recommendations would hinder them from that.
Let me talk a little bit about credit ratings then.
Okay.
You agree that utility credit ratings are an indicator of relative financial risk, is that correct?
No, I think they're an indicator of overall risk, financial and business.
Okay. So it's, you did include financial in your response, but it's broader than that as well, if I'm understanding your testimony. Is that correct?
That is correct.
Okay. Can I have you look at table CCW3 on page 9 of your testimony?
I'm there.
And here we're looking at Standard & Poor ratings of the electric utility industry from the years 2009 to 2022. Is that correct?
That is correct.
And if we look at just the last 3 years that are shown on this table, 2020, 2021, and 2022, we see that A, which is the highest rating, there's been a reduction from 14% in 2020 down to 10% in both 2021 and 2022, correct?
Yes.
And then the A- rating, we're seeing a reduction from 2020 of 53% down to 37% in 2021 and 2022, correct?
Yes.
And what we're seeing is that the credit ratings for the utility industry in recent years are now a large percentage of them, 35, 36% in 21, 22, are at the BB plus rating, correct?
Yes. I'd agree with that.
And we're seeing also that the BB rating, a triple B rating, for utilities is also growing at 16% in both 2021 and 2022, correct?
Yes.
So what this table shows is an overall decline in the overall credit rating for the electric utility industry, correct?
Only for those 3 years, but I included all the way back to 2009, where we've seen substantial improvements since then.
Right. But we're seeing pretty substantial changes, downgrading in the last 2 years. Would you not agree?
And there are a few reasons why that is.
But it is happening in the industry, right?
Yeah, but it is, and it's related to the ratings of the parent companies.
So you have talked about the fact that PNM's current ROE is 9.575, correct?
I believe that's accurate, yes.
And are you aware that S&P downgraded PNM in 2020?
And I am aware.
With its current
and
rating?
I am aware of that, but I do not believe that the ROE was a mentioning of that. It was a downgrade.
Was a mentioning of that?
The ROE was not mentioned as a reason for that. And by that, I meant downgrade.
Okay. And let's look at figure CCW1 on page 5 of your testimony.
Figure 1 on page 5?
Yes, figure CCW1 on page 5.
I'm there.
And this is, I guess, a graph of authorized ROEs for the electric utility industry.
It shows both electric and gas, but yes.
Okay, electric and gas. Do you agree with Dr. Woolridge, who submitted testimony in this case, that 2020 and 2021 showed record lows for approved ROEs relating to electric utilities?
Yes, I would agree with Dr. Woolridge that 2020 and 2021 were record lows.
And your graph shows that there's been a bit of an uptick beginning in 2022 in approved ROEs compared to the record lows that we saw in 2020 and 2021?
Yes.
And this graph that you have presented with regard to electric utilities, it includes observations for distribution-only utilities, right?
Yes, it will.
And PNM is a vertically integrated utility, right?
It is.
And as a general rule, vertically integrated utilities have a higher ROE, approved ROE, isn't that correct?
It seems logical. I don't know that I don't think I've checked the difference between distribution only and vertically integrated every year. So I don't know. I mean, like I said, it's logical, but I have not verified the differences.
Okay. And so far in 2023, we've been seeing increases in authorized ROEs for electric utilities, have we not?
Relative to 2022's average of 952, the year-to-date average is 964 through yesterday. I believe the median is 959.
Okay.
So marginal increases.
And you're aware that there have been some approved ROEs above 10% in 2023, correct?
I think there's been two. Most recently was an Alaska decision where they were awarded 1145, which included a 100 basis point premium for what the commission described as, well, I'm paraphrasing here from recollection, unique risk based on their geographic location and isolation. But I would also note that 1145 represents a 50 basis point decrease from 1195, where they awarded that in 2017.
Okay. All right. Those are my questions. Thank you very much, Mr. Walters.
Sure.
Thank you, Mr. Alvidrez. I had the Water Authority down for 10 minutes. Mr. Herman?
Thank you. No question, Mr. Examiner.
Thank you, Mr. Herman. Hearing Examiner Ryan?
Yeah, I have a few just follow-up questions with Mr. Walters. You can correct me if I'm mistaken about this, Mr. Walters. I'm asking a question that's a legitimate question, so feel free to educate me. When I hear Mr. Alvidrez and the company point out that the utility is going through a transformation, and it's bringing on board technologies and generation assets that are very different than the way these companies, or that support functions that are different than the way the companies have operated previously. I guess my question to you isn't that like a real positive for an investor?
That's a really good question. First and foremost, nice meeting you, Hearing Examiner Ryan.
You as well.
Yes, generally speaking, as utilities invest in rate base, that enhances future earnings and cash flows. So it provides shareholder value through that. So yes, it is a positive generally for investors. If they don't invest, they continually depreciate, rate base declines, and then you're seeing declines in earnings. So generally investments in plant and equipment would be considered positive, especially as you get further on down the road.
What does the change for the company? I mean, maybe has no consequence in that.
Hold
if
on,
that's the
Hearing
case.
Examiner Ryan?
Sure, yeah, go,
It's
Mr.
a little bit more complicated than that, though, because it depends on what the investments are in, right?
Yeah, certainly. But that's why I say it was just generally speaking, investments in plant, property, and equipment
Have you?
provide
ahead.
shareholder value later on once they're in service and accounted for in rate base.
Have you looked at the impact of grid enhancing technologies on the level of utility investment? GETs?
I don't believe I'm familiar with the, that proportion of it. No.
Okay, well, that's just a point. You're not familiar with something that, and I'm not critical of you, but that is an issue, right? That grid enhancing technologies are an important function on the transmission system that might allow for more renewable energy to be added. But there has been some resistance by utilities to adding that because why? In part because the transmission upgrades that go into rate base are more expensive and therefore earn more of a return than some of the grid enhancing technologies. You see, so that's just one slight little slice of a problem that we face going forward, is the resistance in some areas and the lightness of touch, if you will, on requiring utilities to look at grid enhancing technologies on the transmission system. So I just want to point that out as we go along, that this is, while yes, on balance, on a rough level, adding more transmission is important, adding more different investments to the utility system are important. There are some gray areas here. Go ahead, I hear you, Zana Ryan. I've been itching to say that, by the way, for a while.
My next question was going to be, it's sort of in the same vein that Mr. Medeiros just, the line of questioning that he went towards, which is, does the nature of the investments, and I'm thinking in this case, grid modernization investments, as opposed to say investments in large coal plants or any of that kind of stuff, change the calculus at all, as far as you're aware?
Change the calculus as far as what?
In terms of what's needed to attract investors. I mean, so does it, where we have the grid modernization proceeding, which actually the revenue requests there are actually, I think, greatly eclipsed what we're dealing with here. And that's like a whole different set of investments. It's a technology web that allows, consumers to play a more active role in their energy use, and then the utility itself to see more on a real-time basis what's going on with the grid. And I guess I'm wondering, as an investor, I mean, does that factor into that's where this is all going, factor into what we do, what we should think about the return on equity and what's needed to attract capital?
Yeah, sure. That's an interesting question, and one that we could think about. One thing to note is that investors can't just invest into a single specific project. They invest in the company as a whole, right? So, and I've been a part of proceedings around the country where they've tried to get premiums to the ROE based on renewable investments or otherwise, saying that kind of capital, that's what's needed to attract the capital, and I've advocated against that. And it's just becoming more of the norm. So keeping up with this, what we're experiencing as an industry trend should not earn or be awarded any kind of enhanced ROE, if you will, based on the specificities of the projects. But like I said, you really just can't invest in single projects. You invest in the company. And then we're looking at a company specific ROE here.
Mr. Alvidrez also noted the cap that exists for PNM in terms of what it can earn, and that if it exceeds a certain threshold, it has to push that money back to ratepayers. Does that impact the attractiveness of the company from an investor perspective?
Well, I think, we have to look at it as you have to balance the interest of shareholders and ratepayers here. So that's built in some kind of protection for ratepayers. And as I noted in my testimony to Mr. A question proposed by Mr. Alvidrez, that they are, utilities are afforded a reasonable opportunity to earn their authorized return. If they are not earning their authorized return, they have mechanisms in place that allow them to seek the ability to increase their level of earnings, i.e. through rate cases. It's not so easy for consumers. So to my knowledge, consumer complaints are not as easy to file as rate cases. So I don't know that it's a hindrance. And those earnings sharing mechanisms, or earnings caps, if you will, symmetrical or asymmetrical, are relatively increasing in popularity. I know in North Carolina, it's an asymmetrical one currently. That's been my most recent experience with one, at least.
So if I understand correctly, what you said there, and I'm just going to restate it, and you can, correct me if I'm wrong. Those caps are sort of a risk mitigation metric that favors the ratepayers. Is that basically correct? What I've just said there?
I wouldn't say that it favors, I say it protects. But yeah, it's more of a ratepayer protection than it is shareholder enhancement.
But it does preclude, and I guess I assume this is the point that the company's trying to make, which is, you're not going to get an outsized earning on this investment. It's impossible.
Well, I mean, the investments in total, right? Because they're going to be earning a return on their total investment base. So the earnings cap of, I believe, 50 basis points. I mean, yeah, but in general, you're not going to be earning an outsized return. And if you do, you're going to be crediting that back to ratepayers because they've overfunded the utility.
So that basic concept is that's accurate. If that's what the company's point is, that's correct.
The point is that if they're not going to be earning an outsized return, given the cap, then yes, I would agree with that.
Those are all my questions for Mr. Walters. Thank you, Mr. Medeiros.
Thank you, Hearing Examiner Ryan. Mr. Gould, redirect.
I think you're muted, Mr. Gould.
That's another ratepayer protection right there. Mr. Walters, do you recall the questions that Mr. Alvidrez asked you about your testimony in case 20-0038?
Yes.
And you had mentioned that your testimony or your support for the stipulation in that case was based on a number of factors. And could you just generally describe and briefly describe the factors that led you to support that stipulation that had a 54% cap structure for that utility?
I don't have the exact list of all the factors. I would like to note that it's a stipulated agreement between the parties in the rate case that were the result of weeks-long negotiations where there were give and takes from all the parties. And at the end of the day, everybody was happy with the outcome in total based on that give and take.
Would it help the commission in evaluating your testimony if the commission had access to the entire certification of stipulation to put your response in context?
It's been a few years since I've looked at that stipulation, but I don't know how descriptive it is, if you will. But yeah, it would provide context for sure of the giving and taking from the parties.
And in that case, if you recall, SPS came in with a proposed ROE of 10.35%. Does that refresh your
sounds-
recollection?
Yeah, that sounds familiar.
And you recommended in your direct testimony a ROE of 9.4%. Do you recall that?
Yes, I believe it. Yeah, I think that's right.
And in the stipulation, SPS agreed to an ROE that was 100 basis points less than what they had requested. They agreed to 9.35% ROE.
Yes.
And was that a factor in your willingness to approve or to agree to a 54% equity factor in the cap structure?
Yeah, as I mentioned, you take everything into consideration in a whole, and the parties believed that after all that, we thought that the overall rate of return was reasonable.
And SPS also agreed to a significant reduction in their revenue ask, did they not, in the stipulation?
Yes, I don't recall what it is, but
Okay.
it was quite significant.
And if you recall, in the final stipulation, the stipulation was a black box. And I'm going to read you something from the stipulation and see if this refreshes your recollection. The reconciliation statement is required by Commission Rule 1.2.2.20A2 and the procedural order in this case. However, SPS avers that the reconciliation statement, that is of the final rates, is not used for any other post-rate case purpose. The limited application of the 9.35 ROE and the 54.72 equity ratio will not be used for any carrying charges, for example, AFUDC going forward, and does not prevent the Commission from establishing a different ROE and WACC for a rider or regulatory asset. Does that refresh your recollection about what the Commission approved?
Yeah, I recall that, the 9.35% in overall rate of return could not be used in deriving the actual revenue requirement. It was just for a reference piece to be included for some kind of reporting purposes. And I believe you just mentioned WACC. Just to clarify, if it's not in the record, WACC is weighted average cost of capital.
Thank you for that clarification for the record. And you believe that there is a relationship, a dynamic relationship, as you stated to Mr. Alvidrez, between ROE and cap structure, do you not?
I do believe that, yes.
And that the higher the ROE, that should have some downward impact on the cap structure. Is that a fair statement?
Yes, and it's often a recommendation of mine if one way or the other, if they get a some kind of enhanced capital structure, an ROE reduction, oftentimes I recommend something in the lower half of my range. And there's been, I even quote a commission order in my testimony in that regard, that the Arkansas Public Service Commission finds that the two components must be congruent, and I throw air quotes around that. So yeah, there's definitely a relationship between the common equity ratio and the cost of equity.
Do you recall the cross-examination by Mr. Alvidrez about the ability of the utility to raise capital in relation to the ROE?
Yes.
Were you aware that the majority of the resources that PNM has added in the past several years and has continued to add are being done pursuant to purchase power agreements rather than actual investments by PNM?
I recall some testimony on that lines, yes.
Would that impact that use of PPAs versus debt or equity to build plant? Would that impact the utilities need to raise capital?
Not, I can't recall of a time where it did. Those certainly are considered in ratings assessments in the overall financial health of the utility. But I don't recall a time where it's prohibited access to capital.
No, I didn't mean that. I guess I should ask a clearer question. If a utility is ramping up its use of renewable energy, but is using the process of purchase power agreements to acquire that energy, doesn't that lessen its need to raise its own capital?
I mean, again, yeah, it's not going to be upfront. You're not going to be paying, in totality upfront for the PPA versus the project itself, the cap, if you're investing in the actual plant and equipment, because there's going to be lease payments and purchase power payments that go on throughout the future. So I don't think it's going to increase the need for capital, no.
Okay. Do you recall the questions that Mr. Alvidrez had for you about that chart in your testimony about the look like a downgrading over the industry of utility credit metrics?
Yes, well, the credit ratings.
Credit ratings, excuse me. You had answered in response to him. There were a few reasons why that is, and that was not followed up on. Could you state those reasons?
Yeah, there's been, well, the primary reason is the parent company. Let me back up. So this is based on the S&P methodology, right? Because these are S&P ratings, and S&P operates under a family or group rating methodology where there's the rating for the parent, and typically the operating subsidiaries are no more than one notch above or below the parent. Most often they are the same rating as the parent. Having said that, so obviously the parent rating influences or dictates what the operating subsidiary rating is going to be. And one of the main reasons during this time is that, or why we're seeing the degradation over these most recent 2 or 3 years, is twofold. One being, and the major one being, the parent companies operating at minimal financial cushions. So they're taking, over this time during, they were doing a lot of acquisitions, financing with a lot of debt. So the parent company capital structures were more inflated by debt. And then 2, we had a handful of scandals come through that really degraded a couple of utilities. You're talking Commonwealth Edison up in Chicago, and First Energy in Ohio, where they were downgraded after they got caught in some political pay for play scandals.
Some blackmail.
Yeah. So people are serving jail time recently over that. But yeah, so S&P has noted, one, the financial lack of financial cushion at the parent company or the holding company, and then what are known as ESG factors, environmental, social, and governance, and that governance factor being a play with the scandals playing out.
I have 2 more questions, Mr. Hearing Examiner, with your indulgence.
Yes, we're over the 10 minutes, but go ahead.
You had mentioned in response to Mr. Alvidrez that the S&P downgrade of PNM was not tied in the S&P reports or the downgrading analysis to the commission's decision to award a 9.575 ROE. Could you explain what the S&P analysis was?
Yeah, I believe it was along the lines of kind of what I just went over, is that, at the parent company, they expected the financial metrics to weaken because there was lack of financial cushion. And, that you're talking 2.5 years after the rate case outcome. So I don't think that there's a direct tie to the rate case decision. And in my recollection of that report, there was no mention of the ROE of 9.575 as being a reason for at PNM being a reason for the downgrade at PNMR, the parent.
And one final question, you had mentioned a recent report that showed the current debt equity proportions of PNM or PNMR. Could you provide a specific site to the report that you mentioned in response to Mr. Alvidrez?
Let's see here if I've quoted something, if you don't mind. Give me a second.
Thank you.
All right, so if we can turn to page 34 of my direct testimony. Page 34, lines 8 through 11. I make note that the FERC reported equity ratio for the period ending March 31, 2023 was 49.31%.
Thank you. Those are all the questions that I have, and thank you for your indulgence, Mr. Maderos. But I do have a request that we can deal with after Mr. Walters has been dismissed.
Thank you, Mr. Gould. Mr. Walters, when I said blackmail, I blurted out blackmail in the context of Furnace Energy, Ohio. What I meant to say was bribery and crass public political corruption instead of blackmail. So I just wanted to clarify. Is that consistent with your understanding of what happened in Ohio?
Yes, generally, I agree with that.
Okay, thank you. Anything further, Hearing Examiner Ryan?
Just very quickly, and it's a follow-up point from Mr. Gould and Mr. Walters. You can feel free to tell me no, that that's an irrelevant consideration, the end point of this. But he asked you the question about the PPAs, right? And so the utility PNM is now going to collect through an adjustment mechanism a great deal, and seemingly increasingly a great deal of its generation, right? So in theory, I think Mr. Gould's point was that should reduce the amount of risk that this company, it would lower ostensibly the ROE because it's a less risky company. And that's what I understood his point to be.
And maybe I misunderstood his question, but
Maybe I did.
Maybe it was a bad question. I think that's probably the default.
Well, have I understood your question, Mr. Gould? I mean, did I correctly state back?
Both the risk and the need for capital.
Okay.
So,
Mr. Walters.
Go ahead. Thank you.
Me, I would say
Yes.
that the PPA rider, it's those costs are immediate pass-throughs generally, so it eliminates a lot of the lag, and it doesn't require nearly the capital as such that investments in plant, property, and equipment and generating assets would need. So in a sense, it could potentially reduce the risk, but at the same time, like I mentioned, rating agencies consider the present value of lease payments in their assessment of the adjusted debt ratio where they do their credit rating assessments. So I mean, it increases risk, decreases risks. I don't know that there's any kind of net positive or detriment to the overall risk profile. And again, going back to the point that you're investing in a company and not necessarily single projects or PPAs. I'd take a more holistic approach in consideration of risk.
Well, and that's because that's my point. Ultimately, I think about, okay, so we're not investing tons of money in a giant nuclear plant. We're not investing tons of money in these coal-fired plants. The future is going to be putting solar panels on people's rooftops and then creating technology that allows them access to the cheapest energy possible. And in some ways, I guess my point in saying all that is, that's a much more customer-centric investment strategy, which itself seems like a much less risky endeavor simply because it directly benefits the customer, like grid resiliency, hardening, all of these subjects. They're not some remote thing that just exists out there. They're all directly attached to my life. And I'm just wondering if that is relevant to the ROE considerations.
I certainly didn't take that into consideration in my ROE recommendation specifically. I think you're seeing a lot of the utilities making these similar investments. So to the extent that it is considered, it's kind of baked into the analysis with the proxy group.
I guess my point is just more broadly, when you say we look at the holistic nature of the company, I asked at the grid mod proceedings, are you becoming a technology company? And PNM said, no, we're not becoming a technology company. And they're gonna push these costs out to consultants and people who are going to come in and run all these things for them. But that seems to me also like a risk mitigation factor. You have experts integrating all these communication networks between decentralized generation and customers.
Yeah, that's an interesting concept, and I can't say that I've really put much thought down that line of thinking, specifically as it relates to those particular types of investments and into the future. But
That's fine.
I'll certainly go back and look into that and see if that warrants any extra consideration.
It might not, and it's perfectly fair if that's the case. It's more just a thought that I had. So,
well, you and I are learning together then, so I'll take that in consideration and do some research.
thanks, Mr. Walters.
Anybody have anything further with Mr. Walters? Very well, Mr. Walters, we're all learning together and we appreciate you and your testimony in this endeavor.
Thank you. It was nice meeting you all, and have a good day.
Likewise, sir. Look forward to seeing you again.
Thanks. Likewise. Bye.
You're excused. Thank you. Bye.
Thank you.
All right. Let's go out on break until 11:15.
Could I make my request before we do? Because I just want to keep this neat.
Yes, we're still on the record.
What I wanted to ask the hearing examiners is if we could take, or they could take administrative notice of the certification of stipulation in case number 2000238 and the final order approving that certification of stipulation, just to put context around the testimony around the cap structure, the ROE, and the total deal that was done by the utilities and the parties in that case.
I don't think it's necessary to take administrative notice of the certification stipulation. That's something that can, that's subject to judicial notice.
And so we can cite that in our,
Yes,
sorry.
sir.
Okay, that's all then that is sufficient. Thank you so much. Appreciate it.
Thank you. All right. If there's nothing else, let's go on recess until 11:15 a.m. Thank you all. All right, we are back from our morning break on this day 11 of the P&M rate case hearing. Mr. Marks?
Hello, Mr. Maderos. Dr. Fisher indicates he is available tomorrow. He's except for the period between 11 a.m. and 1 p.m. Mountain Time. So that would indicate that probably best to take him after the lunch break tomorrow, if that works. For the
Not
rest of the schedule
available.
on Wednesday morning, first thing.
He's not available today.
He would be available today. I'm meeting with him at 1. What time were you thinking of today?
2 or 3-ish, 3
Okay.
possibly.
Okay, can we do that tentatively then?
Yes, there's no objection to that.
Okay,
Hopefully, I don't have counsel for P&M on yet. They have half an hour with Dr. Fisher. If Dr. Fisher goes today, sometime this afternoon, would that be acceptable to P&M?
Yeah, that's Mr. Gifford. I don't know that he has a half hour, but yes, it would be acceptable to put him on today.
Thank you. And then the other loose end right now that might, let me pull up my new witness schedule that I was working on. since we potentially will get we will get Dr. Fisher on today. I'd prefer to do that if we could. Is all the rest of the witnesses could testify today and tomorrow except for Ms. Ramey. Mr. Borman? Since
Yes.
Ms. Ramey cannot testify on Friday, is that right?
Well, I can check with her again. I think it would be tough for her to testify on Friday. I know she can't testify today.
Well,
Yeah.
that means there's only one witness on Monday, and that's Ms. Ramey.
I think if we're done with everybody tomorrow except for Miss Ramey, let me check with her, but I think we could get her on.
Okay, thank you.
And yeah, I just wanted to make sure, I think this has been made clear earlier, but regardless, Mr. Sidler cannot go Monday. He has to be done sometime this week, either today or tomorrow.
Well, I have Mr. Sidler going first for staff.
Yeah,
Still.
and yeah, to get him out of the way, which would be fine.
All right. Thank you, Mr. Borman.
Sure.
Okay, anything else before we move to the Water Authority's next witness? Mr. Herman, go ahead then.
Thank you. The Water Authority calls Mr. Andrew Harriger. May he please be sworn in?
Mr. Harriger, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Good afternoon, good almost afternoon, Mr. Harriger. Good morning.
Well, it's afternoon in Ohio.
Could you please state your name, title, and place of employment?
Yes, my name is Andrew K. Harriger, Harriger. My place of employment is Sawville and Associates. That's SAWVEL. And my position here is a consultant.
Do you have what's labeled ABCWA Exhibit 3 in front of you?
I do.
Could you please identify it?
Yes, that's my corrected direct testimony in this case.
Was it prepared by you or under your direction?
Yes, it was.
Do you have any additions or corrections to make?
Yes, I do.
Could you please let us know?
Yes. First is on page 5, line 2. The end of that sentence said AKH-7, that's AKH-8 is the correction. The other one is on page 19, line 11, and that's Roman numeral 4, IV, should be Roman numeral 3.
And with those corrections, is that evidence true and correct to the best of your knowledge?
Yes, it is.
And if I ask you those same questions today, would your answers remain the same?
They would.
With that, I move to admit ABCWA Exhibit 3.
Is there any objection? ABCWUA Exhibit 3 is admitted.
With that, I will pass the witness.
Thank you, Mr. Herman. Mr. Williger, we have you down for 35 minutes, and that's the only cross-examination requested of Mr. Harriger. So please proceed.
Thank you. Good afternoon, Mr. Harriger.
Good afternoon.
So you are requesting that the commission approve a 7-to-1 on-peak cut ratio for the well, let me say it more clearly. 7-to-1 on-peak to off-peak summer ratio for PNM's proposed TOD pilot. Is that right?
Yes, that's correct.
And then you would also ask that the commission approve a 4-to-1 for the non-summer months on peak to off peak ratio. Is that right?
Correct.
And that's just for rate schedule 11B. Is your request is centered on rate schedule 11B, is that right?
Yeah, that's correct. Yes.
And is the basis of your recommendation with the commission approved based on the stipulation in the 2016 rate case, which was case number 16-00276 UT?
I would say yes. Yes.
So your argument is that the rate schedule 11B should have a unique TOD pilot rate just because that's what we agreed to previously? And in that stipulation?
No, I would say, so it's consistent with the current time of use, the existing legacy time of use rate. Part of the reason that was agreed to in the stipulation was, as most of you may be aware, but rate 11B is a energy only rate. So the time of use rates are designed to where the existing legacy time of use rates are 12-hour periods, being 8 a.m. to 8 p.m. And part of that design is to encourage customers to shift their load from on-peak to off-peak periods for a number of reasons. One of those being energy prices during the day, typically, especially in the summer, traditionally are higher, than off-peak periods. On top of that, has been discussed and by many other witnesses in this case, the top demands, one winter peak demands, with 3 of those occurring in June, July, and August. So part of the other piece of that is shifting demand costs or shifting the need for future investment in capacity or transmission assets for the company down the road by moving their load to off-peak periods. Now, going to the time of day rate, those ratios are lower, and the period of time is shortened for the on-peak period. So the reason why, what you said about the last rate case, that is part of the reason, but the other part of this is that, if the goal is to shift load out of that on-peak period, and that was the goal with the legacy time of use rates, which were 12-hour periods, then when you shorten the period of time, in essence, there should be even more incentive to shift out of that period. But the way they're designed is that, you're going from a 7-to-1 ratio in the legacy rate to I believe it's 4-to-1 is what was proposed by the company. So the incentive, in my opinion, the incentive has decreased to move out of that period by doing that.
So let me ask you, you understand that PNM's TOD is a pilot rate and they're trying to get a good statistical sample to measure customer responses. You understand that that's the case, is that right?
Yes, I do.
And having a different on-peak to off-peak ratio for one customer class could skew the results or the understanding of how that pilot works in terms of 11B as compared to other customer classes. Would you agree with that?
Yeah, but I would expect that the company is going to be measuring that response based on the customers that participate, knowing which rate class they're in. So, if you have a different ratio for 11B for the time of day rate than you do in other classes, that doesn't mean that the participation rate, that they won't be able to see that it's not transparent. You'll still be able to see within that class what the participation rate is within that class. And part of the participation rate, in my opinion, is if you're encouraging customers to move to that rate, it depends on what their existing rate is. And in the case of rate 11B, if their existing on-peak ratio is 7-to-1, they are already unique from the other classes in that they have a higher ratio currently.
So did you review, I assume you did because you cited it, Mr. Herz's testimony in support of the stipulation?
Sorry, Mr. Who?
Herz, Herz, sorry, Mr. Lee. Mr. Herz's testimony on behalf of ABCWA that was filed in support of the stipulation in the 2016 rate case?
Yes.
Okay. And you understand that the basis of, or from his perspective, the basis of increasing the ratio from on-peak to off-peak for rate schedule 11B was to incentivize off-peak usage. Is that generally your understanding?
Yes, and it's also, it's also to be more in line with rate 4B and 3B that have demand rates. Those classes are different in that they're charged for demand. So, it makes sense that their ratios are lower because you're not, the company is collecting demand costs through a different mechanism than they are in rate 11B.
And in that, as part of Mr. Herz's testimony, to get to that, to make it more aligned with rate 4B, part of Mr. Herz's testimony in the 2016 rate case indicated that ABCWA was choosing to move its Southside Water Reclamation Plant from rate 4B to 11B, right?
Correct.
So the decision point of whether to have a demand rate or not, as it applies to traditional TOU or to be on the TOD rate, I mean, that's a choice that ABCWA made, and they decided they wanted to move the majority of their usage to a rate schedule that does not have a demand charge. Would you agree?
Yes, and the reason really the underlying reason of that was there was an agreement. I won't use abbreviations, but this, like you said, South Water Reclamation Plant, SWRP, they have generation. So, there was an agreement with PNM at the time that really needed updated. And there were a number of options that were being explored about designing or proposing a partial requirements rate. And a lot of those would have been a pretty major change for the company, or had to develop a new rate to do that. And part of that discussions with PNM at the time, and rate design staff at PNM, Ms. Chan is probably maybe the only one that was there at the time, but was that, one of the options is to move them to rate 11B because they do qualify for that. So some of it was a simplicity thing as well, to not have to go through the process of renegotiating a brand new rate schedule, to renegotiate an older rate that was applied to that particular rate 11B customer, or excuse me, water authority customer that was a rate 4B and then moved to rate 11B.
Do you think that the rate 11, maybe you can just speak for your client, ABCWA, do you think, in terms of your request for the TOD pilot, do you think ABCWA needs more incentive than it has currently to shift usage off peak, such that we should make a unique TOD rate just for rate schedule 11B?
I don't think they need a unique incentive. My argument's centered around the fact that they already have more of a unique, design now. So, their existing time of use rates have a different on to off peak ratio currently. So my argument is more around keeping that consistency with the pilot that's being offered, to stay within that same range.
But just again, that determination of giving 11 or providing 11B with a unique ratio and legacy time of use rates was part of the stipulation, right?
Yes, and it was supported by evidence of the other rate classes that have demand rates. It was demonstrated that if you didn't have demand rates on rate classes that most of these 11B customers would likely qualify under, if there was not a rate 11B, that those would be, that would be, actually the ratios would be much higher if all the demand costs were moved to the odd peak period. But we are not advocating for that. I am not advocating for that. And I'm trying to be reasonable with it, to not say, go all the way up to 14 or 15 to 1, because I don't think that's reasonable. But there should be incentive in that you're moving, or you're helping the company avoid future investment. And if that future investment is transmission or capacity, that are on those peak periods, those costs should be included in that at a higher rate. And it should be similar to the existing. I mean, if the company wants customers to move to this rate, and then that's where they want to go down the road, at least in the case of rate 11B, that would be consistent with their existing time of use rate structure.
You understand that rate schedule 11B is the most heavily subsidized non-lighting customer class based on the cost-based rates or the cost-based increases for this rate case. Do you understand that?
Yeah, there's some of my testimony that lowers that number a few percent, but yes, however, there's been several cases that it's been the other direction. So
And
I know, sorry, go ahead.
how many no, you finish your answer first. I'm sorry.
So I'm trying to think of where I was, excuse me. Sorry, can you repeat the question again? I lost track of where I was.
Yeah, here's what your answer was so far. Yeah, there's some of my testimony that lowers that number a few percent, but yes. However, there has been several cases where it's been in the other direction.
And the question was about the subsidization of rate 11B.
Right. Okay. Thank you. So part of the unique situation with the water authority is that, and I state this in my testimony, but that, they have equipment installed that allows them, where operationally possible, they move as much as they can into the off-peak periods. Whatever price signals are given by the company, they do what they can to move their load, which of course they cannot move all of it. And my understanding of what's happened in the last couple of years, especially with what was in the base year, was drought conditions have caused them to, they've been forced to move a little bit more on peak than what they'd like to make sure that their tank levels are at a certain level. And that part's outside of their control, but if conditions improve or something changes, they will be moving whatever they can into off-peak periods wherever possible. So I've been behind the scenes for the last couple rate cases, assisting Mr. Hers, with some of his testimony. It's been a number of years ago, but, I know there's been, kind of some back and forth on, there's such a large percentage of their costs, that are allocated to rate 11B that are determined by those peak periods, especially the 3 summer, 1 winter period. So, and that links a little bit to the few percent I said, that the subsidy is a little less, in my opinion, than what they're proposing, the company's proposing, but having to do with the ESA cost allocation. And that being, you have a 3 summer, 1 winter, and then now they're proposing a different one that in fact is in the summer, is in an off-peak period. So, that in turn then allocated more costs to the water authority because of that change.
And how many customers are there in 11B?
So I think, if I can, I'll go backwards. I believe the water authority has about 100 customers in rate 11B. And I don't have off the top of my head what the total, I feel like the total may be 130 in the class, but I'm not sure about it. I'd have to check that.
So it's a subset of the water authority's customers that comprise rate 11B.
Yeah, it's I would say most of their accounts now are on rate 11B, yes.
Most of their accounts
Of the water authority's accounts, yes.
are in 11B.
Correct.
So it's not just heavy users, industrial users. So when you talk about these, well, so 11B applies only to the water authority, right? Or other customers, or other, are there other customers of PNM?
I think there's 1 or 2 other customers in rate 11B. Yeah.
Can you describe 11B?
11B is a water and sewer pumping rate. And it's currently the legacy time of use TOU rate structure is a 12-hour on peak and 12-hour off peak. It's energy only, and it has a customer charge like other rates. I believe historically the customer charge has been set at cost or attempted to be set at cost. And then any demand costs that are allocated to that class are then collected through the energy rates.
Thank you.
Through the energy rates?
Yes.
Thank you.
Okay, Ms. Twilliger, I'm resetting your time to 20 minutes. Go ahead.
That's actually all my questions. So I'm good.
Okay.
Thank you.
Great. All right. Thank you. Hearing examiner Ryan?
Nothing for me, thank you.
And nothing for me, really. I've already bothered Mr. Harriger with my questions. Mr. Herman, any redirects?
Yes, some brief redirect. Thank you.
Sure.
Mr. Harriger, going back to the questions about the customers of 11B, the number I have off the top of my head is that ABCWA represents about 80% of the total 11B load.
Yeah,
Is that
that sounds
approximately
right.
correct?
Yes, that sounds right. Yep.
Approximately.
Mhm.
So there were several questions by Mr. Williger about the water authority here requesting a unique bill. You recall those?
Yes.
What would, I have some questions about the use of the term unique. Because if ABCWA is an 11B customer and approximately 80% of their customer, wouldn't every bill under ABCWA be able to be classified as unique?
Yes, and I I would agree with that. Yeah.
And again, the pilot program itself is unique.
Yes.
So, and I, as it is a pilot program, I would almost say every proposed pilot program for every rate class is going to be unique. Would you disagree with that?
Yes, the rates themselves, yes, would be unique between the different pilot rates. Yes.
And that pilot program is voluntary, correct?
As of now, yes. Mhm.
So in order to actually participate, there would need to be some incentive for the water authority to do so, correct?
Correct.
And do you know how ABCWA generates revenue to pay its electric bills?
Through billing its customers.
And who are primarily the water authority's customers?
They would likely be nearly all PNM electric customers.
And either residential or some commercial or.
Yeah, yes.
Thank you. That's all I have.
Thank you.
Does the water authority, Mr. Harriger, have any renewable generation like solar panels?
Yes, they have solar.
Battery storage?
They currently do have solar behind a few locations. I think one of their larger ones is at the water plant itself. But yes, they've made several investments for solar, which in an attempt to lower their usage on peak as much as possible, in addition to shifting load. Yes.
And is the water authority a qualifying facility?
I believe they are, but I'm not sure.
Okay. Hearing examiner Ryan, anything further?
Nope.
Mr. Herman, did I spur anything?
No, That just raised some questions for myself about whether or not the water authority is a qualifying facility. I was under the impression since it's behind the meter, it's not a
Right.
qualifying facility.
Yeah, it
Yeah.
may not be because of that. Yeah.
Okay, thank you for that clarification then. Mr. Arago, really appreciate your testimony. And it's been enlightening for me, so I appreciate it. You are excused, sir.
Thank you, sir.
Thank you. All right, would Water Authority please call its final witness?
Yes, thank you. The water authority will call Mr. David Garrett. May the witness be sworn in.
Mr. Garrett, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Good morning in New Mexico, afternoon in Oklahoma, Mr. Garrett.
Good morning.
Do you have in front of you what's been labeled ABCWA Exhibit 2?
Yes.
Can you please identify that exhibit?
This is a copy of my direct testimony.
In this case,
Yes.
was it prepared by you or under your direction?
Yes.
You have any additions or corrections to make?
No.
Is that testimony true and correct to the best of your knowledge?
Yes.
And if I ask you those questions again today, would your answers remain the same?
Yes.
With those answers, I will move to admit ABCWA Exhibit 2.
Any objection? Hearing none, ABCWUA Exhibit 2 is admitted.
And I will pass the witness.
Thank you, Mr. Herman. Now, yesterday evening, Mr. Alvidrez, I believe that the company waived cross-examination of Mr. Garrett. Is that correct?
Yes, sir, and that's still our position.
Thank you. Okay. But I do believe that hearing examiner Ryan had some questions for Mr. Garrett. So go ahead,
Yeah.
hearing examiner Ryan.
Thank you. Hello, Mr. Garrett. On
Hello.
page 8 of your direct, just to confirm, I think it's just a typo. The line 9, it should be 6.13, right?
Yes, I believe that is right. So need to make that correction. It should be 6.13.
And I only ask because in these contexts, those little changes make quite a difference. So I thought I'd just note it for the record.
Yes, the number in the figure
Right.
2 is correct. Yes.
That's the right number. Okay. I was trying to have a conversation yesterday with, gosh, I don't remember the witness, frankly. So many people have come. What is the consequence? Yeah, it might have been Dr. Woolridge. Yes. So what is the consequence and why are you the second witness to bring up this issue of double leveraging? Like, why should the commission be concerned about this?
Well, I guess one thing I would say is even if the commission is not concerned with that at all, it wouldn't change my position because you still have to apply the CAPM properly when you're using a proxy group of companies with a different debt ratio than the target company you're studying. You still have to make that adjustment. But for the double leverage aspect, I think Dr. Woolridge described it very well, where basically you have debt at the parent company that's being treated as equity at the operating subsidiary. So you're getting an equity return on debt. So if you're borrowing debt at a much lower rate, less than half of the cost of equity. And so it's kind of an arbitrage, not that term is usually used in this context, but it's kind of I don't know if you'd say a free return, but in some ways, I mean, if you could borrow money at 4% and then get a 9% return on it without really, I wouldn't say guaranteed, but almost guaranteed, that's a pretty good deal if you can get it. But the problem here is it comes at ratepayers' expense, and I wouldn't describe that arrangement as fair.
So it comes at ratepayers' expense by the amount included in the revenue requirement for the return on equity. Is that am I right?
Yes, essentially so. I think the way to rectify that is to make that what I call a rate making capital structure adjustment. And then also setting the ROE at an appropriate level. It mitigates those. I mean, the fact that there's this discrepancy in the debt is fine. I mean, they can operate, the company can however it wants to as far as capital structure goes. We just need to make sure that what we're using for rate making purposes ends up being fair.
And is the point too that as we're considering the capital structure and what it should be, there's debate obviously about what it should be. I mean, is the point of referencing double leveraging that, the equity proportion of the company is inflated in some ways? It's not represented in what they're providing the commission?
Well, could you, I mean, it is, as far as what's on their books, I mean, that part is accurate. I just think the effectively the parent is being enriched beyond what would exist in a normal competitive market arrangement, I guess, by this technique, which is essentially getting an equity return on debt. So which you couldn't just do in a competitive marketplace without taking some extra risk or something like that. You can just get like a free return necessarily. I don't know if that answered your question.
Yeah, I think it does. Yeah, no, that's fine. I think that answers. I believe I comprehend.
Yeah, I was going to say not to get off this topic, as it is important, but I would go back to, sometimes I don't even mention double leverage because the point still absolutely applies, even if you don't even consider double leverage at all. For the application of the CAPM to be really mathematically accurate in this context, we're using a proxy group to estimate the cost of equity of a company that, you need the proxy group for those inputs, your stock price, you need publicly traded companies, but you have to bring the capital structures in line. And in this case, I think there's two ways to do that. You can have a rate making capital structure that's imputed that is equal to the proxy group average, or the ROE would be mathematically adjusted downward. This is not some subjective determination that I made, but using that Hamada model, you would adjust the award. I mean, the cost of equity estimate at the proxy group capital structure, I estimate at 8.8%. Using this mathematical adjustment, the Hamada model.
How do you spell that?
Yes, it's HAMADA. And that's been around a long time for this exact purpose. If you're trying to estimate the cost of equity of a company that isn't publicly traded and you want to use the CAPM, you might use a proxy group of companies in the similar industry, which is pretty much, it's what we're doing here. But you need to make sure that if this proxy group had a different capital structure than the utility you're estimating, you have to reconcile those because there's a difference in financial risk. So this isn't some concept I created. The Hamada model has been around a long time. And if you just apply that, then PNM's cost of equity estimate is 8.3%. So regardless of your initial CAPM, different analysts are going to have different opinions. You really, for it to be accurate, you still have to adjust it downwards. It would be it's like an error. If we were in a finance class and we didn't do that, we get the problem wrong. So it's a very basic concept.
And has to be adjusted down. And then that relates to the point about double leveraging. How?
Well, they're related. I was kind of making the point that even if you didn't even want to consider double leverage and totally took that issue off the table, my recommendation and the Hamada model, this idea would still apply. But double leverage relates to it too, because that's more of the kind of the unjust enrichment, you could say, of the parent, if you want to describe it like that.
Um, that actually is all the questions I have for Mr. Garrett. Thank you, Mr. Garrett.
Thank you.
Thank you, hearing examiner Ryan. Any redirect? Mr. Herman? I'm
I
sorry.
said no. No,
Oh,
no
I'm sorry.
redirect.
Okay, sorry, my hearing's bad. Mr. Alvidrez, did you have anything else with Mr. Garrett? Or anything with Mr. Garrett?
No, Your Honor, as we indicated, we did waive, but I appreciate the opportunity, the renewed opportunity.
Thank you. Okay, Mr. Garrett, enjoyed your testimony too. And as with your father, I believe, it was a pleasure having you, sir, in this case.
Thank you.
Thank you. You're excused. All right, we've concluded the water authority's witnesses, and I think we should move to Kroger's witness, if that's right, Mr. Bain.
Thank you, Your Honor. Kroger calls Justin Bieber.
Mr. Bieber, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Good afternoon, Mr. Bieber.
Good afternoon.
Can you please state your title and your place of employment?
Yes. My title is I'm a principal at Energy Strategies, and our address is 111 East Broadway, Suite 1200, Salt Lake City, Utah, zip code 84111.
Did you cause to be filed a direct testimony on behalf of the Kroger Company, marked as Kroger Exhibit 1, and rebuttal testimony on behalf of the Kroger Company, marked as Kroger Exhibit 2?
Yes, I did.
Do you have any changes or corrections to this testimony?
No, I do not.
I move for the admission of Kroger Exhibits 1 and 2.
Is there any objection to the admission of either of those exhibits? Hearing none, Kroger Exhibits 1 and 2 are admitted.
Thank you. And I pass the witness.
Thank you, Mr. Bain. Mr. Williger, we had you down for 5 minutes. Is that correct?
That's correct. And sorry for the late notice, Mr. Bieber, but we're going to waive cross. So thank you.
Cross is waived for Mr. Bieber. Hearing examiner Ryan?
Nothing for me. Thank you.
And I don't have anything either. So apologies, Mr. Bieber, for the late notice there in Salt Lake City. You are excused. We appreciate your testimony in the case, sir. Thank you.
Okay. Thank you very much.
Thank you. Okay, so let's moving along with Mr. Bieber having appeared. We would be, let me check my list here. Because I
Staff,
expected
Mr. Sidler,
well, unless,
Mr. Fisher.
right, Dr. No, not yet. Maybe a little bit later on. We're
We're making things tough for Mr. Lee, Mr. Maderos. We're scrambling. We can have him ready around 2.
all right, let's shoot for 2 then. So let's move to staff's choice of witnesses to appear now. Mr. Borman, could you please call staff's first witness?
Well, I'd call Jack Sidler. I've reached out to him. I haven't heard from him yet. I don't know if he's on the wake up. No.
Negative.
You got him?
No, I do not. I do. He's not in the way. He's not in the waiting room.
Okay, let me Try to get him on.
There he is,
Oh, you got him?
being admitted.
Okay, thank you. Welcome, Mr. Sidler. Can you say something so we can hear that your sound works?
Hello, good afternoon.
Hi.
Did you hear me?
Yeah, I can hear you. Can the court reporter hear you?
Yes, sir.
Okay. Staff calls Jack Sidler. Could the witness be sworn, please?
Mr. Sidler, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
I do.
Good,
Thank you, sir.
Well, for one more minute, good morning, Mr. Sidler.
Good morning.
Can you say by whom are you employed and in what capacity?
The New Mexico Public Regulation Commission is an engineer in the utility division.
As part of your duties in that position, did you review the application by Public Service Company in New Mexico that is the subject of this case, along with the testimony filed therein?
Yes, I did.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
Okay, you should have a document marked as Staff Exhibit 7. Do you have that document?
Yes, I do.
Can you identify it?
It's my prepared direct testimony for this case.
Okay, was Staff Exhibit 7 prepared by you or under your supervision?
By me.
And do you have any changes or corrections to Staff Exhibit 7?
No, I don't.
Okay, if I ask you today the same questions as are set forth in Staff Exhibit 7, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Mr. Hearing Examiner, I move admission of Staff Exhibit 7.
Any objection? Hearing none, Staff Exhibit 7 is admitted.
Mr. Sidler is available for cross-examination.
Thank you, Mr. Foreman. Now, Ms. Twilliger, I believe the company does not have any cross-examination from Mr. Sidler, is that correct?
That is correct.
Okay, but the Water Authority did reserve, I think it's the Water Authority, let me check the matrix.
That's what I have.
Yes. Mr. Herman?
Seems like he's stepped away for a moment, I think, perhaps.
Right, he might be on childcare duty.
Yeah,
Just wait a second to see if he comes back, because he had indicated earlier, if I'm not mistaken, that any cross-examination that might happen in his absence would be waived, but I want to give him the opportunity to come back.
I can ask Mr. Sidler a question as we wait.
Please do.
And Mr. Sidler, just one question. You recommend approving the depreciation rates
Yes, I
that were
do.
proposed by the company? That includes the accelerated depreciation of the gas plants?
Yes, it does.
What's the basis for that recommendation?
Just the fact that the gas plants are going to be be shut down in, what is it, 2040?
Does the fact that there's no abandonment plan factor into that analysis in any way?
And no, it didn't at that time, with this time.
Should the commission be certain it has an abandonment plan before it allows for the depreciation rates to be adjusted?
I don't believe it's necessary.
Why is that?
Because at some point, I believe that the plants may be converted. It depends on the plant, whether it can be converted to hydrogen. But at this time, it doesn't appear that they're gonna convert plants. And I don't believe that changing the depreciation schedule is actually applying to abandon the plants.
If I understand, some of the other interveners' position would be, or is, allowing the company to accelerate the depreciation, increases the revenue requirement, increases the rates for present customers, and then that's problematic. You don't share that view?
I didn't hear any of those arguments, but I don't know that I necessarily share it.
Okay, those are all questions I would ask Mr. Sidler as we await there he is.
Thank you, Mr. Examiner. Pursuant to my earlier statement this morning, I'll waive my cross of Mr. Sidler, and if I'm not present for any other witness, I think you can safely assume I'll waive that cross as well.
Okay, I forgot that you might have waived the cross of Mr. Sidler. I'm sorry for that.
As did I. It's too many details.
I didn't specify Mr. Sidler directly, but have some other commitments that I have been pushing off during the duration of this rate case. So and other commitments. So if I'm not responsive, please assume I waive.
Thank you, sir. Okay, Mr. Foreman, any redirect?
I don't have any redirect for Mr. Sidler. Thank you, Jack.
Thank you.
Thank you, Mr. Sidler. Good to see you.
Nice to see you too, Mr. Medeiros. And
Take care.
Mr. Ryan.
Okay, Mr. Sidler, that's a knife edge pass, I think.
What's
I
that?
believe that's the knife edge pass on the screen there. The
Yeah.
airplanes, when they
Yeah,
fly in that, I think that's called a knife edge pass.
Yeah, it's the Thunderbirds, and I think you're probably correct.
Nice. Okay, well, the remainder of the staff witnesses, their cross-examination is 8/10 of an hour for Daschenau, 1 hour for Malden, 7/10 of an hour for Dunn, and 1.4 hours for Ramey. And we do want to get Mr. Fisher on at about 2 o'clock. We did take a late break. Is there one potential staff witness that we could start with?
Well, I think we had identified Christopher Dunn as being our that we would put him on after Mr. Sidler. I don't.
Is he available?
I-
Yes.
Yes, he is. He's in the waiting room.
If he's in the waiting room, I guess he's available. So
Well, let's try and put Mr. Dunn on then, and then go to lunch. So staff, Mr. Borman, would you please call your next witness?
yes, staff calls Christopher Dunn, please.
There he is, in the best room in the building.
So my Zoom background would make it appear anyway, right?
It would.
Just for the record, I would let the public know that this morning we came into the office and here in the Bochum building, and the sink in the men's room on the second floor fell off the wall. So
Yes, Mr. Ryan did point that out to me this morning.
it just fell off the wall, and we walked in and there's just a sink hanging on by plumbing in the bathroom. So
That's not what you're looking for to start your day.
no, I just would note that the public's willingness to provide for us a new facility is greatly appreciated.
Yes.
And I guess I should note to the public that this is not my actual location in the PRC building, right? This is a Zoom background only.
No, and I would have been inaccurate because that's not the background I was thinking of actually on reflection. So,
Mr. Lee, could you swear the witness, please?
Would you please raise your right hand? You solemnly swear the testimony you're about to give to the matter up and should be the truth, the whole truth, and nothing but the truth itself.
Yes, I do.
Thank you, sir.
Absolutely,
Good
Mr. Lee.
afternoon, Mr. Dunn.
Well, Mr. Gorman, just into that afternoon hour, aren't we?
Just barely. By whom are you employed and in what capacity?
Yes, I'm employed by the New Mexico Public Regulation Commission as an economist in the utility division.
As part of your duties in that position, did you review the application by Public Service Company of New Mexico for an increase in rates along with the testimony filed along with it?
Yes, sir, I did.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
You should have a document marked as Staff Exhibit 5. Do you have that document?
Yes, sir, I do.
Can you identify that document?
Yes, this is the prepared direct testimony of Christopher E. Dunn on behalf of the New Mexico Public Regulation Commission, Utility Division staff.
Was Staff Exhibit 5 prepared by you or under your supervision?
Yes, sir, it was prepared by me.
Okay. Do you have any changes or corrections to Staff Exhibit 5?
No, I do not.
If I asked you today the same questions as are set forth in Staff Exhibit 5, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
At this time, I move admission of Staff Exhibit 5.
Any objection? Hearing none, Staff Exhibit 5 is admitted.
Mr. Dunn is available for cross-examination.
Thank you, Mr. Borman. Mr. Alvidrez, we have the company down for 30 minutes with Mr. Dunn.
I believe that's correct. Yes, sir.
Please proceed.
Good afternoon, Mr. Dunn. My name is Rick Alvidrez. I'm one of the lawyers representing PNM in this matter. It's a pleasure to meet you.
Hello, Mr. Alvidrez. Pleasure to meet you as well.
So I want to start out by talking about your recommendations with respect to PNM's capital structure in this case. And as I understand it, staff's not opposed to PNM's proposed capital structure. Is that correct?
That's correct.
And that opinion is based on the fact that PNM's capital structure falls within the ranges of other utility capital structures. Is that one of the bases for your opinion?
Yeah, that's one of the bases for my opinion. Staff did analyze the authorized capital structures for utilities in recent years and found that PNM's request was within the range that was deemed appropriate based on those recent decisions and those recent authorized capital structures.
And you agree that it's important that PNM's proposed capital structure include a reasonable equity ratio in order to allow PNM to maintain its financial integrity, correct?
I would not disagree with that statement.
And you understand that PNM is in the midst of transitioning from large carbon emitting resources to more renewable resources?
Yeah, I think consistent with what you're seeing with utilities throughout the nation, PNM is also, moving away from those carbon intensive resources and moving more towards a renewable generation portfolio.
And that transition will be capital intensive in your opinion, correct?
It will require access to capital. I don't think unique in any sense greater than other utilities that are making similar transitions.
But would you agree that we are seeing increased capital spending by utilities in the recent years?
I've seen some data that indicates, yes, that there is increased capital spending by utilities.
And PNM will need to access capital to implement its energy transition, correct?
As I understand things, it will be necessary for PNM to access capital in order to reach the goals that are accompanying that energy transition, yes.
On page 12 of your testimony, you begin to discuss credit ratings, correct?
You'll give me just a moment to get to page 12. I'll make sure that I am looking at the same thing you are here. Yes, page 12, I begin a section discussing credit ratings.
And at the bottom of page 12 and going over to the top of page 13, you note that the industry average S&P credit ratings have degraded from A- to BBB+, correct?
That's correct.
And you go on to state on page 13 that the downgrades have outpaced upgrades by more than 3 to 1, a ratio of 3 to 1, right?
Yeah, I believe that that's as noted in a footnote there, a recent report, S&P Global.
You indicate at page 13 at lines 9 through 11 that the deteriorating credit ratings for the utility industry can mean that accessing capital can be more challenging. Is that also a fair understanding?
Yes, that's what my testimony indicates at lines 9 through 11.
And would I be correct to say that credit ratings are widely referenced as a guide to the risk associated with a particular company or industry?
Yes, they are one of the primary guides that is used to assess that risk.
And would you agree that a deteriorating credit rating indicates the risk associated with a particular industry or company has increased?
I'm sorry, could I ask you to say that question again, Mr. Alvidrez?
Yes, would you agree that a deteriorating credit rating indicates that the risk associated with a particular industry or company has increased?
Deteriorating credit rating would imply an increased risk relative to a higher credit rating.
Okay. And you understand that PNM's credit rating is lower than the average for the utility industry, do you not?
It is, I believe PNM is at a triple B by S&P and Baa2 by Moody's, so slightly lower.
Okay, and that means that PNM's investment profile is regarded as more risky than the industry average. Is that also correct?
If you're isolating and identifying the credit ratings as the primary risk measure, that would be a indicative consideration, yes.
Okay. Can we go to page 16 of your testimony?
I'm there.
And at line 9, you indicate that an important factor related to credit ratings is their use as a risk indicator with respect to comparable peers, right?
Yes.
And what we're talking about there is investors looking at credit ratings of one utility versus a peer utility and the difference in their relative credit ratings, correct?
Yeah, so I mean, this is one of the risk factors that investors will look at when considering what is a fair comparable peer, and they would compare among those between the peer group and the subject utility.
Jumping back to page 15 of your testimony, and at line 10, you say, for PNM, it is important to maintain investment-grade credit ratings for institutional investors such as banks, insurance companies, trust funds, mutual funds, and pension funds to purchase the company's debt issuances. Correct?
Yes, I see that.
And you go on to state that any decrease in credit rating could lead to higher perceived risk and additional costs to both equity and debt financing. And that's at on page 16, lines 11 to 14.
That's correct.
And PNM's current credit ratings are only 2 notches above non-investment grade, correct?
Yes, that's correct. And it's an important factor to consider. It's considered in staff's recommendations, of course.
And PNM's current approved ROE is 9.575%, correct?
Yes.
And in this case, you're actually proposing that PNM's ROE be lowered to 9.45%, right?
Yeah, staff established a range of an appropriate ROE recommendation for PNM, and within this particular context, the recommendation from staff is that a 9.45 ROE would be appropriate for PNM.
And wouldn't you agree that credit rating agencies would likely consider a lower ROE for PNM to be a credit negative?
I think that there are many factors that credit rating agencies will consider whenever they're evaluating a credit rating for a company such as PNM. ROE would be among those considerations, certainly, but it's not an isolated only factor that will influence their credit rating.
I agree with you, but it is one factor that they look at, correct?
Yes, one of many.
On page 16, beginning at line 1, you note that maintaining access to capital markets is particularly important when economic conditions worsen and make it more difficult to obtain financing on favorable terms.
Yes, to obtain financing under favorable terms, correct?
Okay, and a recession would be included in the concept of worsening economic conditions that you're talking about there, right?
Yes, one could generally one would not consider a recession to be great economic conditions. So
is it correct that lower credit rating suggests that PNM's risks are slightly higher now than they were in the last case? And I should have prefaced that by saying you do understand that in 2020, PNM's credit rating was lowered by S&P.
I'm sorry, I believe you have a couple of statements there. Could I ask you to separate those out?
Let me lay the foundation. And do you understand that PNM's credit rating was lowered by S&P in 2020?
Yes, I'm generally aware of that.
And is it correct that a lower credit rating suggests that PNM's risks are slightly higher now than they were in the last rate case?
If the credit rating was higher at that time and it has decreased, it implies one measure of increased risk as evidenced by those credit ratings.
Okay. Yeah, and let me change gears a little bit here. You are familiar with the Value Line investment survey, are you not?
Generally speaking, yes, it's yes.
And in fact, you have used the Value Line Electric Utility West and Electric Utility Central as screens for the selection of your proxy group, correct?
Yes, staff identified utilizing the Electric Utility West and Electric Utility Central as a screen for staff's proxy group under the basis of trying to identify utilities that are generally in the same region as PNM, consistent with Bluefield Waterworks versus Public Service Commission.
I'm sorry, consistent with
Bluefield Waterworks versus Public Service Commission of West Virginia case. Sorry about that, Mr. Lee.
And I think you just confirmed you included companies from Value Line's Electric Utility West in your analysis, right? Your proxy group.
That's correct.
And would you agree that the goal of the Value Line publication is to present investors with information that's useful in making investment decisions?
Can you state that for me again, Mr. Alvidrez?
Yes. Would you agree that a goal of the Value Line publication is to present investors with information that is useful in making investment decisions?
Yeah, I believe you had said the goal, and I wasn't comfortable to say that was perhaps the only goal. I would assume that is a goal of the Value Line investment surveys. Yes, is to provide reasonable and actionable information that allows investors to make informed decisions based on the information that's included in those investment surveys.
Would you agree that the Value Line is widely available and often referenced by investors?
It's not a free service. It does necessitate a license to access it. And certainly I don't believe that makes it widely available to everybody. Within the investment community, it is certainly a resource that is frequently cited and often used, but the specific availability might depend on the capability and resources available to the investor that's potentially utilizing it.
Would you agree that Value Line is often cited as a resource particularly in ROE calculations in regulatory proceedings?
I have specifically only for this case studied relevant regulatory decisions in New Mexico and some isolated information from other jurisdictions. But generally speaking, I think that that's a fair statement. It is utilized within regulatory rate case decisions within the context of evaluating an appropriate ROE.
Would you agree that Value Line is considered a reliable resource of data for conducting ROE analyses?
One of many, yes.
Okay. Do you have access to PNM's exhibits?
Believe I do.
Can I have you look at PNM Exhibit 66?
Is council going to be sharing these exhibits on the screen, or is?
I believe I can.
It comes with highlighting.
It does.
Oh, okay.
Are people able to see it?
Now I do.
Okay. So do you recognize this as the April 21, 2023 Value Line publication, at least a portion of it relating to Electric Utility West industry?
I'm looking for something. Okay, I see Value Line there on the chart, and I see April 21st, 2023, the title of Electric Utility West Industry. So I believe that is consistent with what you have indicated, yes.
Okay. And I'd like to scroll down to green highlighted section here. And actually let give you a moment to read that entire paragraph that I'm sort of referencing with the green highlight. Can you read that or have access to it?
You're looking, I believe I see three green highlights identifying separate sections on this page.
And
are you identifying the one that is on the first column, the third paragraph down?
Yes, the paragraph begins recent 3 to 5 year total.
Okay. You've asked me to take a moment to read this in its entirety?
Yes, if you don't mind.
Okay.
And focusing on the green highlighted section, it said we'd still like to see roughly 10% to 11% long-term total annual return potential.
Mr. Hearing Examiner, at this point, I'm going to object. Mr. Alvidrez is basically reading into a record a document that he has already indicated he's not going to move into evidence. So he's basically just trying to get this into the record in some fashion. PNM had an opportunity to include this document in its rebuttal testimony. It chose not to. And so, he hasn't established yet that Mr. Dunn has used this particular document in preparing his testimony or reviewed it in preparing his testimony. And so, I object to this line of questioning.
Mr. Alvidrez?
Yes, sir. This material, as the witness has indicated, is in effect a periodical or pamphlet, and it has been established by this witness and others in this case to be a reliable authority that experts rely on. And under Rule 11803, which is the exception to the rule against hearsay, regardless of whether the declarant is available as a witness, it provides the following are not excluded by the rule against hearsay, regardless of whether the declarant is available as a witness. And subsection 18 of this rule provides statements in learned treatises, periodicals, or pamphlets. A statement contained in a treatise, periodical, or pamphlet, if the statement is called to the attention of the expert on cross-examination or relied on by the expert in direct examination, and the publication is established as a reliable authority by the expert's admission or testimony by another expert's testimony or judicial notice. If admitted, the statement may be read into evidence but not received as an exhibit.
And
So, Your Honor, I submit that this is proper questioning.
and who is Anthony J. Glennon?
The author of this this particular article.
Is he an employee of Value Line?
I do not know what his employment status is, but
He's an analyst?
noted. Yes, sir.
Objection overruled. You'll have a chance on redirect, Mr. Borman. Go ahead, Mr. Alvidrez.
Yes, sir. And I was reading the highlighted section in this exhibit. It said, we'd still like to see roughly 10% to 11% long-term total annual return potential to be comfortable in recommending a specific equity to utility investors. That level is roughly in line with long-term returns for the broader market. Do you see that?
Yeah, I believe the beginning part of that statement does indicate that there's generally a reduced level of risk in owning utilities as well. And immediately preceding that statement, it also indicates that the median value for the 35 electric utilities covered by Value Line is 8.3%. So I do see that statement. But I believe in isolation, it might be a little misleading if we were to focus only on that and what they are.
So, Mr. Dunn, read into the record the portion before it that you were alluding to just now.
Certainly, Mr. Hearing Examiner, if it would be okay, may I read it into the record if you're asking for that, the entire paragraph there?
Just the part before Mr. Alvidrez started up with after the comma weed, W apostrophe, W-E apostrophe D. The part before that starting with the word recent.
Yes, sir. Recent 3 to 5 year total annual return prospects for electric utilities look a little lean as compared with what we've seen for much of the past year. The median level for the 35 electrics we cover is presently 8.3%. Although there is generally reduced risk level in owning utilities, given that they're regulated monopolies, we'd still like to see roughly 10 to 11% long-term total annual return potential to be comfortable in recommending a specific equity to utility investors.
Okay, thank you. Mr. Alvidrez, go ahead.
Yes, and so, and thank you for reading the rest of that in there, but do you understand this to be that the investors looking at utility stocks are looking for a long-term total annual return in the 10 to 11% range?
No, sir, Mr. Alvidrez, that's not how I interpret this. What it specifically says is that Value Line would like to see roughly a 10% to 11% long-term total annual return potential to be comfortable in recommending a specific equity to utility investors. Just because that's what they are seeking to, they desire to see in order to recommend a specific equity doesn't mean that that's, as a rule, what investors are going to expect is that 10 to 11% based on this one isolated reference.
And Mr. Dunn, you see the last sentence in that paragraph? Could you please read that into the record as well?
Yes, sir.
Starting with meanwhile.
Yes, sir. Meanwhile, the median dividend yield for electrics is 3.6% at present, 130 basis points above the average of all dividend-paying issues covered by Value Line.
Thank you.
Going on in that same column, at the bottom paragraph, it states, we think utility investors can help guard against sagging valuations by being disciplined buyers. The midpoint of the annual total return projections based on 3 to 5 year target price range should generally be about 11% or greater. It goes on to say a hair lower might be all right with some of the higher growth companies. Correct?
Is there a question in there?
Yes, that's what it states, correct?
The midpoint of the annual total return projections based on the 3 to 5 year target price range should be generally at about 11% or greater. That is the statement that is read here, yes.
Okay. So again, they are recommending to investors that they look for a target price range that results in a return of 11% or greater, correct?
Can you state that again for me, Mr. Alvidrez?
Yes, they're recommending that utility stock purchasers look for companies that can provide a return of about 11% or greater, correct?
No, they're stating that the midpoint of the annual total return projections based on the 3 to 5 year target price range should generally be at about 11% or greater. A midpoint is not descriptive or prescriptive for what must be sought. That's a midpoint. That means there's going to be some lower and some higher.
And let's be clear that it's this analyst, Anthony J. Glennon, assuming he's an analyst, who's making the royal we for Value Line recommendation, right? For Value Line, apparently, Mr. Dunn? Is that your
Yes,
understanding of this document?
Yes, Mr. Medeiros. My reading is consistent with what you've articulated there, that this is a single analyst who is using that word we to represent Value Line, but it is this single analyst opinion in this document dated April 21st, 2023.
And you see that second column after the first line after the parens? Could you read that next sentence into the record, starting with it would?
After the parentheses, beginning with
Yes.
it would. Yes, sir. It would also be a good practice to emphasize utilities with higher than average dividend growth prospects. We put the industry median at about 4.5%.
Thank you. Go ahead, Mr. Alvidrez.
Yes, sir. If we go on in this recommendation, in that same paragraph, it says, we discussed dividend growth matters at length in our October 21, 2022 Utility West report. And it goes on to say, avoiding electrics with below average regulatory environments is also a good practice to generally follow. You see that as well?
Where is that?
It is in the same paragraph that I was reading from.
If I may
Same
clarify,
paragraph that you were reading from.
If I may clarify, Mr. Alvidrez, are you asking if I have familiarity with that October 21st, 2022 report?
No, I was just referring to the further recommendation in that paragraph.
Mm-hmm. Yes, I see that.
Okay. With regard to, they do mention regulatory environment, and you cover that beginning at page 17 of your testimony, do you not?
Give me just a moment to move to page 17 of my testimony, if you will. Okay, I'm there. I believe beginning line 16, I pose a question about regulatory environment on page 17.
Okay, and you continue to discuss it over on page 20 of your testimony. Is that correct? Line 3?
Moving from page 17 to page 20, line 3. Yes, sir.
And you pose the question, should the commission be concerned about the impact of perceived risk of New Mexico's regulatory environment on PNM's credit ratings? And you provide an affirmative response to that with an explanation, correct?
Yes, I know that it's important to consider that perception of risk can impact PNM's credit ratings. And it is, again, one of many factors that goes into establishing those credit ratings. And I think it's important not to consider any of these in isolation. And we recognize that they are holistically influencing PNM's credit ratings. Trying to isolate any particular factor might be a bad direction to go.
Okay. Well, I think my time is about up. I appreciate you very much. Thank you.
Absolutely. Thank you, Mr. Alvidrez.
Here, who else do we have with Mr. Dunn? 5 minutes from Bernalillo County, I believe, but Mr. Albright. I'm sorry, did I miss something?
At least according to my map here, oh yeah, never mind, you have it correct.
That was Bernalillo County, but Mr. Albright appears to not be with us this afternoon.
He just joined.
Mr. Albright?
I was just on mute, Your Honor, and the video was suppressed by the screen that was showing
Okay.
the excerpt there. So my apologies for that.
That's fine. You have 5 minutes now, right? Is that correct? With Mr.
Yes, sir,
Dunn?
that is correct. Good
Okay,
afternoon,
please.
Mr. Dunn.
Hello, Mr. Albright. How are you doing today?
Doing well, thanks. My name is Jeff Albright with J. Albright Law LLC, and I'm here on behalf of Bernalillo County. So just a few questions for you. How did you arrive at your 9.45% with regard to the recommended ROE?
Yes, Mr. Albright. I considered a variety of factors, but the two analytical methods that I used to establish staff's range was the discounted cash flow model and the capital asset pricing model. That established my range of 9.34 to 9.66. I also looked at recent regulatory decisions in the state of New Mexico, considering the rate cases that the commission has had it before it recently, the trends that have been established by those recent rate cases, as well as the specific outcomes of those rate cases in regards to the return on equity that was authorized by the commission. I looked at national trends as well, trying to establish, what does the data say when we look at what authorized ROEs have been granted by commissions in other jurisdictions. And I try to consider all of these factors while recognizing again that PNM has to continue to be able to access capital at a reasonable rate that is fair and just, that is allows them to be able to make the necessary investments they need, but also that doesn't overburden consumers by overly enriching PNM with unfair or excessive ROE. So balancing those various factors.
Okay, and you mentioned that there were many factors that go into determining rate of return and so forth. Would one of those factors also include the debt of the company?
The debt of the company would certainly be a factor that would ultimately play a role in an appropriate ROE, because, for example, that the debt of the company may influence, say, the credit rating, which then could be a factor in determining an appropriate ROE for a company.
Did you look at the debt for PNM? And I'm talking about PNM, not the debt of the parent company, PNMR.
Yes, sir.
And do you think that was a factor with respect to the debt that's being carried as far as one of the risk factors that might be at play for investors?
May I ask you to state that question again for me, Mr. Albright?
Yeah, let me try to rephrase that a little bit. You mentioned in your discussion with Mr. Alvidrez that there were many factors that influence how investors look at risk for a particular company. Do you recall that discussion?
Yes, sir.
Would the debt that the company carries also be one of those factors that's considered
Yes,
by
sir.
investors?
Yes, sir. It is one of many factors that would be considered.
Okay, and did you look or determine what the debt for PNM, not the parent company, PNMR, but did you look at what the debt was for PNM?
Yes, I believe it's stated in my testimony, and I can identify that reference if you would like.
No, I just wanted to know if you had considered but that would be certainly one of the factors that would go into risk assessment by investors, correct?
Yes, sir.
Ms. Reno, as our expert, recommended an ROE of 9.26%. Do you recall that?
Yes, sir. That sounds correct. From what I recall of reviewing Ms. Reno's testimony.
And so do you feel that her 9.26 is an unreasonable ROE? And if so, why?
I don't think that I would make a statement one way or another that it is reasonable or unreasonable because I haven't analyzed it for reasonableness. What I would say is that it does fall slightly below the acceptable range that was established by staff by a few basis points, I think 8 basis points.
And do you have any sense for what percentage with regard to the ratings that are established? Do you have any assessment as to how much of a percentage investors put on the ROE? 10%, 20%, 50%, 75% with regard to their own risk assessment?
No, sir. I don't know when you were to analyze that in a percentage scale. I could not give you a number for that. No.
Okay. All right. Fair enough. Mr. Hearing Examiner, I believe that's my time. And Mr. Dunn, thank you very much for your answers and your thoroughness. Appreciate it.
Thank you, Mr. Albright.
Thank you,
I hope you have a good afternoon.
Thank you, Mr. Albright. The next up and last requesting cross-examination time with Mr. Dunn would be Mr. Herman for the Water Authority if he's around.
No questions, Mr. Examiner.
Okay, thank you, Mr. Herman. Hearing, see, no commissioners are on the roster here. Hearing Examiner Ryan, any questions?
Just a
for
few
Mr. Dunn?
questions. It'll be quick. Mr. Dunn, how are you?
I'm doing well, Mr. Ryan. And yourself?
Okay. What linkage is there, if any, between the need for capital and the utility's cost of capital?
That's not something that I've examined. I think that we do see that there is an increased need for capital by utilities as they are transitioning away from traditional carbon intensive resources. You know, that scale of that need could influence, could be an influential factor that investors would consider, but I haven't done any analysis of that. I apologize.
That's okay. And the reason I'm asking is Mr. Alvidrez points out, and I understand why. It's a perfectly legitimate point. Well, we have to go through this transition. It's going to be expensive. So we have to be able to attract capital. And I get all that. I'm just wondering if there's any empirical proof that suggests the need for capital in any way influences the cost of capital. And I guess what you're saying is you don't know.
That's correct, sir.
That's fine. So can you just, I know these are answers you work for staff of the commission, correct?
Yes, sir.
And what interests does staff represent in these proceedings?
Well, staff represents the public interest, and that requires that we consider, basically every customer class, the impact of how these rate case proceedings and any case that comes before the commission will impact the various customer classes, how it will impact the public, how it will impact the company, because the company must continue to operate as a going concern and have the necessary resources that they need in order to provide safe, reliable service to the customers.
Okay, that's good. That's plenty. I follow everything you've just said, and I don't mean to cut you off, but I'll just for everybody's benefit, not to hurry along, but
no, not a problem.
Walmart showed up in these proceedings as that's fine. They did. Okay. Intervener. And, their position was, and in my understanding of reading their testimony, they're thinking about their own business interests. And they note in their testimony, that's Mr. Chris, well, look, if we manipulate the return on equity in PNM's application and turn that down, it results in a significant savings. And I presume that Walmart is saying those things because obviously they have a business to run, and probably their profits are relatively thin in terms of what it's a low cost seller, right? So electricity is going to eat into their profits. All of that's fair to assume, do you think?
I think those are reasonable assumptions. Yes, sir.
And the reason I bring that up is because, who are Walmart's customers? Well, they're people who live in New Mexico, right? And the reason I'm saying that is because I asked Adrian McKenzie, PNM's witness, when we think about the company's return on equity, do we think about the 41% of PNM's customers that exist within the federal poverty lines, 200% of them? And his answer was no. And I understand that answer. The market is a vicious thing and it doesn't care, right? Like, I get that. But does it? Does the commission care about those things as we're thinking about them? And does the commission and you representing the public interest have any contribution to that discussion?
Certainly. I mean, while that's not an area that was specifically covered by my testimony, I do think it's an important consideration that, utility division staff and the commission ought to consider is the relevance of the significant portion of low income customers that reside in our state. Ultimately, I understand Mr. McKenzie's perspective, and I wouldn't stand wholly against it. The market will demand a reasonable rate of return for an investment. That being said, I do think it's fair that, in our considerations of what is appropriate on a great many matters within this case, that we do keep in mind that, yes, we are a relatively poor state within the nation. We have a significant portion of customers who are low income. And while I think that basically what that means is that we must set a return on equity, or the commission ought to set a return on equity that does allow PNM to access capital markets, be able to make those investments that are necessary, but again, doesn't overly enrich the company with a overly burdensome or too high ROE. And I think that staff's recommendation fairly does that. It's a reasonable recommendation that I believe will allow the company to attract capital in the markets through numerous economic cycles. As we know, these rate case proceedings don't come along every week or every month. The rate that's established for an ROE is likely to persist for some time. And I think that staff's recommendation considers all these factors and is fair, and in that sense will provide a fair return to the company. Will provide a fair ROE to the company, a fair return to investors, and doesn't totally ignore the fact that, yes, we do have a significant share of customers that are low income in New Mexico.
It occurred to me as I was just sitting here listening throughout the hearing, the regulatory liability the company would want for the COVID-19 pandemic, that is related to bad debts, that is related to social and economic circumstances. And I understand that's something that's very different than discussions about what is the company's cost of capital. But considerations of the customers' socioeconomic conditions necessarily bears upon everything. I mean, do you agree with that statement?
The consideration of the customer's socioeconomic conditions necessarily bears upon everything. That's not something I've really analyzed, but I think it's a relevant factor.
Okay, fair enough. Thank you, Mr. Dunn. That's all the questions I had.
Mr. Dunn, is this the first return on equity, cost of debt, and capital structure analysis that you've performed on behalf of staff at the commission, or have you been involved in other rate cases doing this before?
That's correct, Mr. Medeiros. I have generally had some discussion of return on equity within the context of other proceedings, such as, its application to riders and things of that matter. But in a general matter of establishing an appropriate ROE for a company, this is the first rate case proceeding that I've offered recommendations on behalf of staff for that matter. Yes, sir.
You didn't do it in the gas company case, for instance, or the SPS rate case?
No, sir.
Well, okay, I just want to make a statement that I greatly appreciate your work in this case. And you're already exhibiting the fact that you're a great asset for the commission and to the public interest. And we look forward to many, many more analyses like these going forward from you. So my way of thanking you.
Yeah, ditto that, Mr. Dunn. Very impressive, sir. And I enjoyed the exchange between you and Mr. Alvidrez. I thought that was nice to see some back and forth.
Very, very impressive, and we look forward to hopefully being able to retain you at the commission. And that's my way of thanking you for a job well done.
I sincerely appreciate that, Mr. Hearing Examiner, and to both of you, Mr. Hearing Examiners, and I'm grateful for those comments.
Mr. Borman, any redirect?
Briefly, Mr. Hearing Examiner, it'll be just a couple minutes. Mr. Dunn, you recall that Mr. Alvidrez and you talked about the transition that P&M is undergoing in their business right now?
Yes, sir.
And I think you kind of referred to that in response to a question by Mr. Ryan, that transition would be from fossil fuels to renewables. Is that what you meant or understood that transition to be?
Yes, sir.
Okay. Now, utilities have in the past invested in these fossil fuel facilities. Is that correct?
That's correct.
Okay. And some of those investments are very significant capital, require significant capital infusions, do they not?
Absolutely.
Okay. Thank you. No further questions.
Thank you, Mr. Foreman.
Thank you.
Mr. Dunn, again, our sincere thanks to you for your testimony and your work in this case. You are excused, sir.
Thank you so much. Y'all have a wonderful afternoon.
You too. Thank you. And nice cat, by the way. Was that a cat there?
Yeah, that's my cat. I happened to notice it over my shoulder, and I thought, well, that's going to live forever on YouTube now, but that's okay.
And while I have you, what is that background, if you can disclose?
I'm actually not sure. It's a standard. I can't remember if it comes from Teams or if it comes from Zoom, but it was part of the package at some point. And I get a lot of compliments on this background, so I guess it's a nice one. But I suspect maybe it's not in there anymore if as a standard offering for Zoom, or else others might recognize it more regularly, But
I'm partial to the Blue Angels personally. I think Mr. Sidler's gets the creative thumbs up.
Well, we should all aspire to be as cool as Mr. Sidler, but someday.
Someday.
Work in progress.
Okay, thank you, Mr. Dunn.
Absolutely.
Well, we should break now for lunch until 2 p.m. when we will hopefully have Dr. Fisher for his testimony and cross-examination by Mr. Gifford, starting at 2 p.m. In the meanwhile, have a great lunch. We're in recess.
Thank you.
I'm going online.
Hey, Mr. Lee, how's this working with these headphones?
That's perfect.
Hey. And could we get an audio check with my witness, Mr. Fisher?
Good afternoon.
That sounds good to me.
Thank you so much.
Sounds good, yeah. I'm ready for my beating, Mr. Marks.
How about for a cold beer?
I'll take you up on it.
Yeah.
You still in business down there?
Yeah, in fact, it's one of my law offices these days. I'm in the back office there.
What a shame.
It's a struggle to stay sober before noon for the hearing, right?
Better
That's
than being in
awesome.
the back office of a nail salon, I guess, but
That's where my office is at. What are you saying, Mr. Borman?
I was at Jimmy McGill's office.
Yeah.
Did I hear Jimmy McGill?
Yeah.
Yeah, he's gonna try utility law as his new career.
Well, good afternoon. Hope everybody had a pleasant lunch. I see that we have Sierra Club's witness with us, Dr. Fisher. Thank you very much, Dr. Fisher, for going out of order and agreeing to come early to testify.
Pleasure
So,
to be here.
thank you, sir. With that, Sierra Club, would you, Mr. Corman, go ahead.
I want to be real brief. We noticed this morning that a couple of the exhibits that we had sent around on September 8th, the updated or corrected exhibits of Jonah Malden and Georgette Ramey had not been included in the Dropbox. And so we sent them around again over lunchtime. The only difference between this and the ones that we sent around on the 8th is these are clearly marked on the cover page that these are the corrected versions. Hopefully they do get put into the Dropbox. But everybody should have them. If you don't have them, let us know and we'll make sure you get them ASAP.
Thank you, Mr. Borman. We did, I believe, receive those exhibits via email from Ms. Regensburg.
Yes.
And I'll make sure that they get uploaded to Dropbox. And there was one other loose end on another staff exhibit, that's staff exhibit 2, PNM's response to staff's 8th set. That was provisionally admitted because it required some additional identifying information, which staff did provide. That was uploaded to Dropbox, and therefore that staff exhibit 2 is admitted unprovisionally, fully admitted as of right now.
Excellent. Thank you very much.
Thank you. Anything else from anyone? Okay. Mr. Marks, would you please call Sierra Club's witness?
Yes, Sierra Club calls Dr. Jeremy I. Fisher to the stand, and I'd request that he be sworn in.
Please raise your right hand. Solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
And for the record, can you identify your name, state your name, and identify who you work for?
My name is Jeremy Fisher. I work as a senior advisor for Sierra Club.
And do you have a document with you that's been marked as Sierra Club Exhibit Number 1?
Yes, I do.
And what is that?
I believe Sierra Club number 1 is my direct testimony.
And was that prepared by you or under your supervision?
Yes, it was.
And do you recall that Sierra Club filed an errata to that direct testimony as originally filed in July on the 12th?
I do.
And is this Exhibit 1 corrected for all the changes in that errata?
I do believe so, yes.
Okay. And is this Sierra Club Exhibit 1 true and correct to the best of your knowledge?
It is.
And if I asked you the questions contained therein today, would your answers be the same?
Yes, they would.
Mr. Hearing Examiner, I move admission of Sierra Club Exhibit 1.
Any objection? Hearing none. Sierra Club Exhibit 1 is admitted.
And Dr. Fisher, do you have a document with you that's identified as Sierra Club Exhibit 2?
Yes, I do.
And can you identify what that is?
That is the Surrey rebuttal testimony filed September 1st, 2023.
And is the testimony contained in that document true and accurate to the best of your knowledge?
Yes, it is.
If I asked you the same questions as contained therein today while you're under oath, would your answers be the same?
They would, yes.
I move the admission of Sierra Club Exhibit 2.
Any objection? Hearing none. Sierra Club Exhibit 2 is admitted.
And Mr. Hearing Examiner, Sierra Club would pass this witness for cross-examination.
Thank you, Mr. Marks. Mr. Gifford, I believe the company has 15 minutes. Is that sufficient time?
Actually, Your Honor, after consulting with my client over the lunch break, we would waive cross-examination of Dr. Fisher.
Well, that's surprising, but fine. Okay. So the cross-examination by the company of Dr. Fisher is waived. Let's see. The Water Authority had requested 15 minutes with Dr. Fisher. Is Mr. Herman available?
Yes,
He
Mr.
is.
Zimmer, we also waived that cross-examination this morning.
Oh my goodness. Oh, that's right. I'm sorry. Okay. Hearing Examiner Ryan?
To me, I was hoping there'd be some questions. I've reviewed all of your testimony, Mr. Fisher, and there's been extensive discussion already about these subjects. I think everything's covered in the testimony. So no, I don't have anything further with Dr. Fisher. Thank you.
I don't either, except to thank Dr. Fisher for his testimony and digging deep on this issue once again, as he did in 2117. So with that, there would be no need for any redirect, right, Mr. Marks?
I think there would be no ability, but if you would give me that.
Right. Well, no. So Dr. Fisher, your testimony is always greatly appreciated by the commission. Thank you, sir. You are excused.
Thank you so much. And I am pleased that I did not have to travel for this brief intervention, but have a wonderful afternoon.
Thank you, doctor. You too. Okay.
Plug for Zoom right there.
Yeah.
Right. So with that, we're back to the staff witnesses, I believe. Is that correct, Mr. Borman?
Yeah, I believe so, yes. And Gabriella Dashino does appear to be in the room.
Yes. Would you please call her your next witness?
Staff calls Gabriella Dashino. Could the witness be sworn, please?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, ma'am.
Good afternoon, Ms. Dashino.
Good afternoon.
By whom are you employed and in what capacity?
New Mexico Public Regulation Commission, the Accounting Bureau Chief of the Utility Division.
As part of your duties in that position, did you review the rate application by Public Service Company of New Mexico along with the testimony that they filed with it?
Yes, I did.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
Okay, you should have a document marked Staff Exhibit 3. Do you have that document?
Yes, I do.
Can you identify that document?
Yes, give me 1 second. Okay, it's my prepared direct testimony of Gabriella Dashino, filed June 23rd, 2023.
Was Staff Exhibit 3 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to that testimony?
I do not.
If I asked you today the same questions as are set forth in Staff Exhibit 3, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Thank you. Mr. Hearing Examiner, I move admission of Staff Exhibit 3.
Any objection?
None from PNM.
Hearing none from PNM or any other party, Staff Exhibit 3 is admitted.
Thank you. Ms. Dashino is available for cross-examination.
Thank you, Mr. Borman. I have the company down for 30 minutes. Mr. Alvidrez, please proceed.
Thank you. Good afternoon, Ms. Dashino. My name is Rick Alvidrez, and I'm one of the lawyers representing PNM in this case, and it's nice to meet you this afternoon.
Nice to meet you. Good afternoon.
So I had a couple of questions about some background matters. You introduced yourself as the Accounting Bureau Chief for the NMPRC Utility Division. Is that correct?
That is correct.
And I see from your educational background, you hold a Bachelor in Business Administration with a concentration in accounting.
That's correct.
Is a concentration in accounting different than a major in accounting?
No, my degree is in accounting.
Okay, are you a CPA?
I am not.
So you indicated that you read PNM's application in this matter and the supporting testimonies. Is that correct?
That's correct.
And you understand that PNM is seeking new non-fuel base rates, in this case, based on a future test year of 2024?
That's correct.
And you agree that these proposed new rates are prospective in nature, do you not?
Yes.
And this case will determine an annual non-fuel revenue requirement to cover PNM's costs to provide retail service to customers, correct?
Correct.
And do you think it's reasonable to anticipate that the new base rates will remain in effect for more than the 1 year?
I would say so.
And during the period that the new rates are in effect, PNM's actual cost to provide retail service will vary from the cost used to set the revenue requirements in this case. Isn't that correct?
Yes, it's possible.
Well, is it you're sort of indicating it's possible? Wouldn't you think that the actual costs are going to vary over time as PNM makes? I'm sorry?
Yes, they will vary over time.
But the revenue requirement, unless someone changes it, will stay the same, correct?
Yes, it will.
And it's reasonable to expect that PNM will make capital investments during the time the new rates are in effect. Do you agree with that?
I agree with that.
And do you also agree that in the absence of a rate case or other rate mechanism, that PNM won't recover the specific costs associated with the new capital investments?
I wouldn't, during the time that the rates are in place, they won't, but they, in a future rate case, may ask to recover those costs.
Right, but they would have to wait to a future rate case, correct?
That's correct.
And to the extent that they've and those rates would be, the recovery would only commence with the new rates, correct?
That's correct.
And do you also agree that plant may be retired during the period when the rates are in effect?
Yes,
And in the absence of a rate case or other rate mechanism, PNM's rates will not decrease to reflect the retirement of capital plant.
not until a rate case is filed. That's correct.
I want to talk a little bit about Palo Verde, which is at issue in this case. You understand that PNM's interests in Palo Verde Units 1 and 2 are certificated resources, do you not?
Yes, I understand that.
And do you also understand that as of the present time, these 2 units have served PNM's customers for 37 to 38 years?
That's correct.
And do you agree that PNM was allowed to include the cost of the renewed 114 megawatt Palo Verde leases in rates as part of the final order in the 2015 rate case?
Yes,
And do you know how long the lease extension period was for the 114 megawatt leases?
I'm sorry, could you repeat the question?
Yes, do you know how long that lease extension was? For the-
Yes, your lease extension, I'm sorry, the 64.1 are going to expire in 2024. So from 2015 to 2024 would be for the unit 2, I believe, and unit 1 is expired as of January 2023.
Okay.
Forgive me if I get
mentioned-
those confused.
I'll let you finish. Let me know.
Okay.
You mentioned something about 64 megawatts. What? At least that's what I thought I heard. Is that, did I understand?
I'm
you
sorry,
correctly?
I may have it confused. I'm sorry. I don't have the exact megawatts in my mind. I'd have to go back. But yes, the final PVNGS will no longer be expired. They'll be expired by the end of this year.
Do you agree that, well, is it your understanding that the 64 megawatt interest in unit 2 will expire at the end of this year?
Yes,
Do you agree that PNM has incurred costs for required capital investments for leasehold improvements
I
for the
agree with
period?
that.
Okay. Let me finish my question, and it's a little bit a long question, but if you give me just a little bit. Do you agree that PNM incurred costs for required capital investments in leasehold improvements for the period of time that the 114 megawatt leases were in effect?
Yes,
And do you also understand that PNM incurred required capital costs for leasehold improvements for the original lease term?
yes,
And do you agree that PNM has been recovering the costs of these improvements, including a return of and on these investments, in rates in accordance with the Commission's orders?
yes. Well, they are until they have expired plant and service, so that would be expected.
Okay. And you understand that PNM has removed all of the Palo Verde lease costs effective with the new rates that would go into effect in January of next year, correct?
That's correct.
Okay. And I take it you don't dispute that PNM's decision to allow the 114 megawatts of Palo Verde leases to expire to pursue cheaper alternatives results in a benefit to customers in terms of lower costs?
That's what PNM has stated, and I did not dispute that in my testimony.
Okay. And in taking the action to benefit customers, PNM is going to be left with undepreciated investments associated with the leasehold improvements. Isn't that correct?
PNM will have undepreciated investments, yes.
On page 9, line 11 of your testimony, I'll give you a moment to get there. Have you found that in your testimony?
I'm almost there. Okay, page 9, line 11.
Right. It says, number one, PVNGS will no longer be used to provide electric service to P&M customers. And you list that as one of your concerns, is that right?
That's right.
So what's the basis of the understanding that Palo Verde will no longer be used to provide electric service to P&M customers?
I guess I could have stated that it will no longer be available to provide electric service to customers based on the expiration of the leases. So it is concerning that P&M did sell those leases, but along with that went the capital improvements.
Well, let me follow up on that a little bit. Is it your understanding that as of the time the leases expire, that P&M will no longer have any interests in Palo Verde?
In the leases that were expired. That
Okay,
is my
just 114 megawatts.
Correct.
And you mentioned that P&M has sold its interest in the leases. Can you explain what you mean by that?
Well, I did get the rebuttal that it did not sell all parts of the leases, that it's just certain assets associated with that. And that's what I was referring to.
Well, what was it your understanding at the time you wrote your testimony that P&M had sold the interest in its leases to SRP?
Yes.
Okay. And I had a question related to that. On page 14, line 14 through 6, I'll give you a moment to get there.
Thank you. Okay, and could you give me the lines again?
Yes, of course. It's page 14, beginning at lines 14 through 16.
Okay.
And you say there, P&M has opted to sell the interest in PVNGS, thus the value of their investments in the plant should be recouped through this transaction to the fullest extent possible.
Yes.
When you prepared this testimony here, was it your understanding that P&M was selling all of its interest in the 114 megawatts to Salt River Project?
Yes, it was.
Okay, and have you subsequently learned that that's not the case?
I have, and I understand that those capital improvements will still be an outstanding cost for P&M, but I also understand that somebody else will be utilizing those investments. The capital investments or improvements that have been done on the leases, and P&M customers will no longer have access to those improvements.
Do you agree that the costs that were incurred related to improvements that were made during the time that this 114 megawatts was serving customers?
Yes, those improvements were made during the time that P&M held those leases for.
So customers did get the benefit of those improvements, correct?
For the time they were in service or are in service, yes.
And customers have not fully paid for those investments, isn't that correct?
Well, I mean, what I've seen in this hearing is a lot of comparisons to plant abandonments, and these are lease expirations, and the customers would be paying for these capital improvements for 20 years down the line if there was any type of approval of these costs. So essentially customers have been paying for these improvements while they were using the electric service provided for.
Right, but they haven't fully paid for the cost, right? That's why we haven't.
That is
created an asset.
P&M's position, yes.
How?
And yes, there are still outstanding costs. I agree with that.
Okay. We've touched on this a little bit, but on page 19 at line 19 and going over to page 20, you refer to the PV-NGS SRP transaction.
Okay.
Is that correct?
19 to 20. Yes.
And at the time you wrote your testimony, what was your understanding of this transaction?
Okay, what are you referring to in the testimony exactly?
So you have at the bottom of page 19, line 19, it says issue number 3, true up of the PV-NGS SRP transaction proceeds regulatory asset. Do you see that?
Okay.
And I was asking you what your understanding at the time you wrote your testimony of what the SRP transaction involved.
Okay. The regulatory asset should not be allowed to. That so transaction proceeds, that the true, I really don't understand the question you're asking me. Like, am I understanding the sale, the transaction of the leases to SRP?
Okay, so let me re-ask the question.
So okay, go ahead.
What was your understanding of the transaction between PNM and SRP in terms of what was being sold and under what conditions?
Same idea. I believed that they were selling the entirety, including the capital improvements.
Okay. And have you since gotten clarification about what PNM was actually selling?
Yes.
And what's your understanding of that?
Like I said earlier, they were selling certain assets associated with the leases. I mean, the capital improvements are on there, but they weren't a consideration in the sale.
Do you know what the assets are?
I'd have to go back to the rebuttal testimony.
Okay. At page 15, beginning at line 4 of your testimony, let me know when you're there.
Okay, I am there.
You state PNM should not be allowed to recover investments in an asset that has been sold to SRP. And what is your understanding of how PNM is accounting for the proceeds of the sale to SRP?
I'm understanding that they are going to return those proceeds to the customer.
Okay. On page 10, beginning at line 6, you talk about another concern, I think, as you characterized it.
Okay.
And you say in item 6, PNM has not computed the portion of savings attributable to the sale and leaseback of the 114 megawatts of lease capacity, according to PNM's response to NE's second set of discovery. See Exhibit GSD-3.
Correct.
And let's go to that exhibit, if you don't mind.
Sure.
That's with the very end of your testimony.
Right, I'm getting there. I'm sorry, my computer is really slow. Okay, I'm there.
So the response there indicates that there was an estimated savings of $259.6 million in 1986 dollars of savings using the sale leaseback compared to using traditional rate making methods. Do you understand that to be true?
Yes.
And if I understand your criticism or your concern, is that there isn't a breakdown of how much of that savings is attributable to the 114 megawatts of leased interest?
Well, I mean, according to the answer here, the statement does not relate specifically to the 114 megawatts of lease capacity that is expiring. The company has not computed the portion of the savings calculated at the time of the sale and lease back.
I'm sorry, the company has not.
So, Ms. Sachsen, I'll just
Computed-
slow down a bit for Mr. Lee's benefit.
Sure. The company has not computed the portion of the savings calculated at the time of the sale and lease back attributable to just the 114 megawatts of leased capacity.
Right. I see that in the answer, but you list that on page 10, beginning at line 6, that's a concern for you.
Well, yes, I mean, in the beginning of my cross, you did ask me a question that if I understood that PNM was saving customers money by expiring these leases. And so with the concern that I don't know how much money it's actually saving the customers.
Well, isn't that two different issues? I mean, one is the savings back in the 1985 and 1986 timeframe attributable to the sale leaseback transaction that they talk about being $259.6 million versus
The customers.
the savings to customers as a result of PNM allowing the leases to expire and obtain lower cost resources to serve customers. Aren't those two different things?
Well, yes. So, but in either instance, there's not a showing of the exact savings for the 114 megawatts of Palo Verde.
Did you read PNM witness Sanders' testimony where he provided an analysis of the estimated savings to customers from allowing the leases to expire and pursue lower cost resources?
I did see that, but I didn't fully examine his testimony as that wasn't, I wasn't addressing the cost of service study.
Well, this was an analysis that was demonstrating it was beneficial to customers.
Could you direct me to that?
I probably can, but I won't belabor the point. It's you indicated you hadn't really focused on it. But getting back to the original question relating to your concern about PNM not computing the portion of savings attributable to the sale and leaseback, what is the concern there? I'm having a hard time understanding why that's an important issue for staff.
Okay, could you ask me that question again?
Yes. What is staff's concern about how much of the 259.6 million savings from the sale leaseback transaction is attributable to the 114 megawatts of
Well,
the extended leases?
I mean, it would help solidify, in my eyes, PNM's position on the decision to expire those leases and what exactly the cost savings is to customers.
But
Visually, I'd like to see that.
But so is it your understanding that the $250 million savings is from allowing the leases to expire?
No, I mean, they allowed him to, but I'm just saying it's just something that would be a visual and an understanding of cost savings. So I just don't have that figure.
So how would you go about calculating that figure?
I would not know if P&M has not done it. I don't think I could compute it just off the top of my head.
Well, no, I wasn't asking you how to compute it off the top of your head at all. But, just practically, how would you do that?
Well, let's see if I go back to, I mean, I am guessing that P&M has a model that could compute that. And when the question was asked in discovery, it didn't do so. So I actually, from my standpoint, I don't know how I would compute it, honestly.
Okay, and you're just guessing that P&M would have some model that would be able to compute that?
I would think so.
Okay. On page 12, beginning at line 9, you discuss stranded costs.
Yes.
And you provide a definition of stranded costs at line 10 through 12. Is that correct?
I believe I do. I'm just trying to get back there.
Okay.
Okay,
Are you there?
I am there.
So what's the source of the definition that you provided there?
I believe I got this from the Accounting Standards Code, the ASC website.
And do you know what section?
Yes, give me 1 second, and I don't. I was just looking at it earlier, and I am blank. $980,360.
Okay.
Is that
this-
980.360?
Dash 360.
And is this a direct quote or your sort of interpretation of the?
It's an interpretation.
So you go on to state at line 12 on that same page that the idea of stranded costs, and more importantly, arguments for its recovery, is a concept with little basis in economic theory, legal precedents, PRECEDENCE, or precedents, PRECEDENCE, in other deregulated industries. And what do you mean by that?
I believe just that if it's a stranded cost, which, it could be considered abandoned plant, could be considered stranded cost. And I'm simply stating that if a company determines it's stranded, then there wouldn't be a recovery issued for it. And I think in determining that it's possible that the utility might have claimed impairment on that.
I'm sorry, the utility.
Might have what kind of impairment?
They may have claimed impairment on it.
I think you mentioned this, at least alluded to this, but did you read the testimonies of other witnesses in this case that provide numerous examples of utilities being allowed to recover stranded costs related to retired assets and specifically power plants?
I did.
And you're not saying that stranded costs are never allowed to be recovered, are you?
No.
And in fact, in this case, you propose that PNM be allowed to recover its undepreciated balance of Unit 1, less the amount of the QIP in that balance and any return on that amount over 22 years. Is that correct?
That was one of the recommendations I made, yes.
So how much is your proposed QIP disallowance?
Mm, And I don't recall the exact amount. I don't think that I placed it in here. I believe Jonah made the adjustment in the cost of service study. I'm just not recalling it offhand.
Okay. You go on to state at page 15, line 6 through 10, that if the commission determines to allow a return of and on the undepreciated balance, you recommended a 50% disallowance of the undepreciated balance and recovery over 11 years. Is that correct?
That's correct.
And you recommend the same treatment, the two options that I just described with respect to the undepreciated investments in Palo Verde Unit 2?
That's correct.
With regard to your alternative remedy, in the event PNM is allowed to recover a return of and on its undepreciated investments, how did you arrive at the 50% disallowance?
Actually took a recommendation. I mean, I know I heard earlier in the hearing that there was a case where that was actually, I don't recall if they said that it was if they earn a return, but I took the recommendation in that aspect because I could not find any historical case data on leasehold improvements and how they were treated. So I used the recommendation from ASC 980-360 that was, I think I have it cited here, in the accounting for public utilities, that's a position that FERC would take for abandonments.
So are you?
And let me, if you want me to cite that for you, I can.
Well, you're talking about FERC says a 50% recovery on abandonments. Is that your testimony?
Yes.
Yeah, I would like a cite for that.
Sure. Give me 1 second to get back there. Okay.
Avidras, we're in an added time, which is fine.
Okay, I'll take some time
Okay.
off of Ms. Reno.
So it is accounting for public utilities. And the section would be 12.03, open bracket 1, close bracket, open bracket A, close bracket 1214. And it is titled Abandonments, and it cites ASC 980-360. And it states all the different ways to account for recovery that the regulator has allowed.
Okay, so it's, is it just a list of various ways that regulators have handled recovery of stranded assets? Is that what you're talking about?
Yes, I can read for you the portion that I took. If
Okay.
you would like for me to read it into the record.
Yes.
Okay. If the regulator is likely to provide a full return on the recoverable cost, the new asset value should equal the original carrying value of the abandoned asset less any disallowed costs. Open parentheses. The FERC has generally adopted a policy of 50-50 sharing between ratepayers and shareholders of the cost of abandoned construction projects, with a full return being provided on the portion recoverable from ratepayers. In this case, the abandonment asset would equal 50% of the construction costs at the time of the abandonment, close parentheses.
So that guidance it relates to projects under construction, correct?
Or abandonment.
Well, they're projects under construction that are being abandoned, right?
The abandoned plant is no longer a physical asset capable of generating revenue.
Okay. Are you aware of other jurisdictions that have allowed a full recovery of the abandoned, the stranded cost?
I am sure there are other jurisdictions that have, and unfortunately, I had trouble finding case history within the PRC
Okay.
when trying to apply it to leasehold improvements.
So for Unit 1, the amount of the stranded asset is $88.9 million in round numbers. Is that correct?
That's correct.
And for Unit 2, that number is $73 million in round numbers.
73 million?
I'm sorry, $7.3 million.
Correct, yes.
And so that's a total of about $96.2 million for both units.
Correct.
And you agree that the commission's determination of imprudence was only with respect to the renewal extension of the 114 megawatts of leases, right?
Well, it's the renewal would have to include these capital improvements because in renewing, they would have had to continue making these capital improvements.
Right, but do you understand that there are also, that part of this stranded cost is attributable to investments that were made before the lease extensions ever occurred?
Yes, that's
You are aware of that?
Yes.
And are you aware that the amount of the undepreciated investments that predate the renewal is $51.3 million of the $96.2 million?
I am aware of that now.
Okay, that wasn't something you were aware of before when you made your recommendation?
That's correct.
So because there was no finding of imprudence with respect to the $51.3 million that took place before the extension, you would agree that disallowance of that amount would not be appropriate, would you not?
The amount that this is the balance of the undepreciated assets at that time. Is that what you're stating to me?
Yes. Attributable to the earlier investments.
And the balance was 51.3 million at the time when they renewed the leases back in.
No, that's the balance now.
Okay. I would agree that that amount before the commission ruled that the renewing of the leases was imprudent, that amount could be considered a stranded cost and be requested by PNM for recovery.
Okay. Thank you very much. I appreciate your responses today.
Thank you.
Thank you, Mr. Albigris. Shall we take 5 minutes from Ms. Reno? If that's what you wanted to do.
You went over
yes,
time,
I'm
Mr.
I'm
Buttigieg.
sorry. Absolutely, yes. 5 minutes from Ms. Reno.
Penalty
Okay.
time.
Added time, injury time.
Yeah, yes, yes. My penalty.
Is that a major?
This is a minor. Minor infraction. No, it's not an infraction at all. We just have to keep moving and try and complete the hearing tomorrow if possible. So, okay. We had the county, Mr. Albright, but I don't believe he's on. I don't know. He might hop on, and I'll just move to the Water Authority, 10 minutes, but I don't know whether Mr. Herman also waived cross-examination this afternoon for Ms. Dashno. And while we're waiting for that, hearing examiner Ryan,
Yeah, just a few questions. Ms. Dashno, how are you?
I'm well. How are you?
Okay, so at your testimony at page 40, what is the subject under discussion is what is staff's position concerning the issue of FCPP prudence, and that's the Four Corners power plant.
Correct.
And you say that those first lines 5 through 7, you explain, and I don't want to read it all just for the benefit of Mr. Lee. You've reviewed Mr. Graves' direct testimony and answers to interrogatories. Now going on to lines 8 and 9. Staff takes the general position that the investments in question were, in retrospect, not demonstrably imprudent.
That is correct.
So if they're not demonstrably imprudent, does that mean that they are prudent?
I took this position in 2117, I believe, where the commission had made a determination on this, and based on the new analysis provided by Graves, I could concede that the commission's decision could stand, but as the analysis was done, it could, and I think after hearing Mr. Graves' testimony, there was flaws in the analysis, but I don't believe that PNM would have changed its decision to remain in Four Corners. Even so, in stating that, I guess I would say that staff is on the position that after the analysis that we don't really see it as being imprudent.
Okay, so then that's I understand that, but then my next question is effectively, is something that is not imprudent necessarily prudent?
No.
So you're not saying here that the investments were prudent, you're saying simply that they were not demonstrably imprudent.
Correct.
And that distinction is valid as far as you're concerned.
Yes.
There's a state of being not imprudent that does not necessarily connote prudence.
Correct.
Okay. I just wanted to make sure it's just the choice of words. If they were intentional, they are meant to convey something. And it seems like what you're saying is, yes, those words specifically convey the concept that I'm teasing out with you. Is that right?
That's correct. I mean, I did take, the position of the commission's decision seriously in 2117. So I couldn't flatly say that everything was a prudent investment decision.
Then down at the page 40, line 17 to 18. Nevertheless, staff understands the position that a deficient investment analysis could be, in and of itself, grounds for a finding of imprudence. So I understand those words, and maybe can you just say what you're trying to articulate here in a way that perhaps
could you direct me to that again? Is that the bottom of page 40?
17 to 18. It's the page 40, line 17. The sentence begins with nevertheless, and it ends with the word imprudent.
Right. A deficient investment analysis could be grounds for a finding of imprudence. And I think that's what I'm saying. The analysis was flawed, deficient. So in that's where I guess there's room to argue that it could be deemed imprudent, but here we are. The analysis was done. P&M supported it again. And, I think it's been heard that it is flawed, but it doesn't exactly determine that it was a prudent investment to continue in Four Corners.
Okay, and so there's been much discussion of this very concept, and I just want to understand staff's position on this. I think it's important to understand it. There is the thought that goes something like P&M cannot point to stuff it discovers after the fact, and use that as a way to, and I'm speaking very colloquially here, so just to simplify
Well,
everything, right?
To be clear, P&M can. You can
They
sue
can.
anyone for anything. People say, "Can I be sued for that?" Well, yes and no, you can, but it could be tossed out too. So P&M can, but whether it's acceptable and whether it's a finding we'd be willing to make remains to be seen. Go ahead.
Yeah, no, I appreciate the clarification. What I'm trying to say, Ms. Dashino, is effectively, the post hoc or the quantitative analysis or the harm analysis, as it's variously been called. Some folks could look at that, and I think there are interveners. In fact, I know there are interviewers taking that very position and say, "No way, you just didn't do analysis," and then you're saying after the fact, well, since there was no harm, no foul. And as a matter of fact, I had that very exchange with Mr. Graves. Is that acceptable to staff?
No, because the issue should have been looked at the time when the investment was made. So it wouldn't be accurate to say, well, look, we made this investment and now customers save money because we remained in Four Corners. And I don't think that was the issue at hand when the prudence, even though it's been rolled forward to 2023 from, where were we, 2016, I believe. Is it further back than that? So, you can't look at it prospectively, or at least that's not how I see it.
Okay. Those were my questions for Ms. Dashino. Thank you, Ms. Dashino.
Staff redirect.
Yes, I have some questions for redirect. Ms. Dashino, P&M's current rate case was filed using a future test year. Is that correct?
That's correct.
What does it mean to file using a future test year?
I'm sorry, what does it mean to file?
What does it mean to file a rate case using a future test year?
Yeah, the future, they're using 2024 as the basis for what their costs and their revenue requirement are going to be going for on a looking forward basis. So rather than using historical data, they're using future data.
And the historical data could include investments made in 2024?
Well, the future test year could include that, yes.
Yes, under the future test year. Now, P&M can file a rate case whenever they wish, is that correct?
That's correct.
And they can file a rate case using a future test year like this case, correct?
Yes, they can.
Okay. Does P&M depreciate its capital assets?
Yes, they do.
And P&M use that depreciation expense to invest in new or upgraded assets?
Yes, they could if they chose to do so.
Okay. Thank you. That's all I have.
Thank you, Mr. Borman. I don't see, we've passed the time for any further cross-examination with Ms. Dashino.
And I do believe Mr. Herman did say to the extent to which he was not present, he acknowledged that he was waiving. And Mr. Albright, if I recall correctly, said something to that effect as well. So
They both did over time. I just wanted to make sure that we didn't forego a reasonable opportunity for them to come back and cross-examine Ms. Daschino, but that time has passed. And it's my time to thank Ms. Daschino. Unless there's anything further from the parties of Ms. Daschino that I don't see anybody requesting. Thank you very much, Ms. Daschino. We really appreciate your testimony on these difficult issues as always.
Thank you very much.
Thank you. You're excused.
Thank you, Mr. Hearing Examiners.
Thank you. Okay, we have 2 staff witnesses remaining. One, well, would staff please call its next witness if you have one available?
I'm monitoring the waiting room. I don't
Sorry,
see anyone at present.
Just, I was muted. I believe we were expecting to have Jonah Malden testify at this.
And
I reached
witness,
out-
you reached out. Would
Jonah
Ms.
Malden-
Ramey,
No, Miss Ramey is not available. I'm trying to get Jonah Malden on. I think that's.
Here we go. He's being admitted.
All righty then.
did you admit him, Ms. Examiner Ryan?
Yes, I did. He's present in the Zoom room, but his video is off and his audio is muted.
Mr. Malden, can you turn on your video and your audio? There he
There he
is.
is.
So can you hear me okay?
Yes, sir.
Yes.
Yeah. Give me a minute to pull up Mr. Malden's testimony.
We've got the Zoom echo. Mr. Malden, do you have your YouTube? Oh, God.
No, it should be closed.
I don't have the YouTube on, so I don't know.
Is
Seems
it
like
from-
it's gone now?
Let me speak, see if it's from my end. No, it's not from my end.
Was it? Now it's gone.
Did that fix it?
Yes.
Okay, cool.
Okay. Staff calls Jonah Malden. And the witness be sworn, please.
Malden, would you raise your right hand, please? You solemnly swear the testimony you're about to get in the matter up and to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Good afternoon, Mr. Malden.
Good afternoon.
By whom are you employed and in what capacity?
I'm employed by the New Mexico Public Regulation Commission, specifically in the utility division, where I hold the position of senior economist within the Accounting Bureau.
As part of your duties in that position, did you review the rate application submitted by Public Service Company of New Mexico along with the testimony filed therewith?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that application?
Yes, I did.
Okay, you should have a document that is marked Staff Exhibit 4. Is that correct?
That is correct, yes.
And was Staff Exhibit 4, well, can you identify what Staff Exhibit 4 is?
Yes, Staff Exhibit 4 is the direct testimony of Jonah B. Malden on behalf of the New Mexico Public Regulation Commission, and it is the corrected version.
Okay, I was just going to ask you, you do had, or you did have some corrections to make to the version that was originally filed. Is that correct?
That is correct, yes.
And you filed an errata regarding that?
Yes, sir.
And those changes in that errata are reflected in the version that is marked on the cover page corrected that you have?
Yes, they are.
Okay. And if I asked you today the same questions as are set forth in Staff Exhibit 4, the corrected version, would your answers be the same?
Yes, they would.
Okay, and are those answers true and correct to the best of your knowledge?
Yes, they are.
Thank you. At this time, I would move admission of Staff Exhibit 4, the corrected version.
Any objection? Hearing no objection, staff exhibit 4 is admitted. And the corrected version has been uploaded to Dropbox and the original version was removed.
Thank you, Mr. Harrington.
You're welcome.
Mr. Malden is available for cross-examination.
Ms. Terwilliger had, the company had 25 minutes with Mr. Malden. Please proceed.
Thank you, hearing examiner. Good afternoon, Mr. Malden. My name is Debria Twilliger. I'm appearing on behalf of PNM. I don't think we've met before.
Good afternoon. Nice to meet you.
So I want to talk about the group incentive plan recommendation you make first. You recommend that the commission authorize 60% of recovery of PNM's group incentive plan. Is that right?
That is correct, yes.
And your concerns relate to employee turnover for those employees that participate in the group incentive plan. Is that about right?
Yes, as well as the shift of risk from ratepayers to, or from the company to ratepayers as well.
And when the commission made its decision that you referenced the 2015 rate case, do you not, about the group and regarding the commission's prior decision for the group incentive plan? Do you recall that at page 16 of your testimony?
Yes, I do.
And you note that the commission stated that the historical data was limited at the time it approved the program. Is that right?
That is right, yes.
And for purposes of your recommendation, you assessed employee turnover in 2020 and 2021. Is that right?
That was what was provided by PNM, yes.
Did you make any adjustment? Well, do you have a general sense that due to the pandemic and companies competing nationally for talent as well as remote work, that employee turnover increased nationwide, not just for PNM, but across the country?
Yeah, I think that's a reasonable statement.
And that employee turnover, in particular in 2020 and 2021, was when the effects of the pandemic were particularly being felt in terms of employee turnover in 2020 and 2021. Would you agree with that?
Yes, I would.
Did you make any adjustment in looking at the historical data to make your recommendation for only 60% recovery? Did you make any adjustments that PNM's data as to employee turnover might have been affected by the broader effect of the pandemic as opposed to the success of the group incentive plan?
I did not, because that data was not available to me. The only data that was available was from 2015 and 2020 and 2021.
Okay, thank you. I want to talk next about the time of day recommendations that you make. Do you believe that transitioning to an effective time of day rate will benefit PNM's customers overall, I should say?
I'm not a rate design expert, but yeah, I believe that's a reasonable statement, yes.
Do you know, or are you aware that PNM's current legacy time of use rate for residential customers has limited enrollment?
I'm not aware now.
Do you believe that effective marketing may be able to bridge the gap and get customers to understand time of day or time of use rates?
Yeah, I think that's a fair statement, yes.
And effective marketing might also get customers more comfortable with the concept of time of day or time of use rates?
Yeah, I would agree, yeah.
Okay. Do you think it's important that customers understand how they use energy in order to effectively make decisions about whether they're using energy on peak or off peak?
Yes, yes, I think informed customers, it would benefit customers as well as load shifting goals. Yes.
Okay. And you've proposed a $1.36 million reduction to PNM's proposed cost associated with the TOD pilot program. Isn't that right?
That is correct. Yes.
So there's 475,000 you disallow for website design
Yes.
and approximately 885,000 for a subscription to an energy data management tool. Is that right?
That's correct. Yes.
And you believe that PNM has the internal expertise to conduct to run an energy data management tool or to do website design? Is that why?
Yes.
I'm sorry, go ahead.
Okay. Yeah, I do believe that PNM does possess the internal expertise to effectively roll out a time of use or time of day rate without the external fee costs. I think that PNM demonstrated that in their transportation electrification plan, where they have a whole home EV rate, and there was no budget for outside services, and that whole home EV rate is, to me, comparable in some respects to a time of day rate, and there was no budget for external services in that application.
Do you know if the whole home EV rate includes an energy data management tool?
I would imagine that it does. I'm not positive, but they are monitoring usage, and I believe that they are installing a second meter for the customers who enroll in that program.
I want to ask you next about your proposed disallowance for the fee-free credit card program. You generally support the program, is that right?
I support the program not beyond 1.5 million, yes.
And in particular, you note, or you seem to agree that this could alleviate cost incurred by low-income customers who may pay for the credit card fee right now if they pay via credit cards. Is that right?
That is correct. I did take that into consideration with my recommendation. In my analysis, I tried to find data that would show if low-income customers have less access to checking or internet or the ability to set up ACH transfers. Unfortunately, I couldn't find very much data on that, but I do believe that the program could feasibly help those low-income customers that don't have access to the free ACH payment method that's currently available.
And so your proposal is to only allow 1.5 million in cost associated with this program, and you base that entirely on historical numbers. Is that right?
Yes.
And that it doesn't account for any growth in the program. Is that correct?
That's correct. The 1.5 million to me represents the known and measurable costs.
And you state that the credit card payment growth rate is largely speculative for PNM's customer base.
Yes.
And I assume you read Mr. Cervantes's direct and rebuttal testimony?
Yes, I did.
And you didn't take into account the fact that other utilities have seen almost 100% growth rate in usually typically the year following the start of the program for their credit card for their fee-free credit card options?
Well, I did look at his exhibits, and to me, it seems that other utilities already had a lot more people paying via credit card than PNM currently does. I believe it's 12.8% currently, and 1.12% that are paying on a guest account via ACH, which also has a charge. So to me, that means that all the other customers are paying via ACH or in person or mailing in a check. So I don't see how what the incentive would be for them to switch their current methodology to a credit card if they are already paying without a fee via ACH.
Well, you listed in addition to ACH via check or some other means, is that right?
Yes.
So you don't see, sorry, go ahead.
No, I was done.
Okay. You don't see any incentive for particularly low-end customers who might be paying by going into payment centers to transition to a payment via credit card based if they have a fee-free program. You don't see that occurring?
Yeah, I mean, there could be incentive there, yes, sir. Yeah, I think that's a fair statement.
Okay, Mr. Malden, I really appreciate your time. Thank you. That's all my questions here in Canoe.
Thank you, Mr. Swigert. Again, Bernalillo County had reserved 5 minutes with Mr. Malden, but Mr. Albright does not appear to be on the Zoom call. And the same for Mr. Herman, who's assumed to have waived time with Mr. Malden. WRA reserved 20 minutes. I see there's Ms. Beatles in X-ray.
Yes. It's adjusting, but only to tell you, Mr. Hearing Examiners, that I have no questions because my topics were covered by counsel for PNM. So thank you.
Thank you, Ms. Beatles. While I have you, have you been in contact with Mr. Botts today?
Yes, but we're planning on him appearing tomorrow. Does that still work for you, or are you hoping that he can go up today?
I would like for him to go today because tomorrow I just added it up, and with Ms. Ramey not being available tomorrow, we have 5.5 hours of cross-examination, not including Sanders and/or Gray, the PNM witnesses. So
I'm sorry.
No, you go ahead.
I will check with him, but he had a handful of conflicts today. So I can't make any representations that it's likely to happen, but I will check with him just to be sure.
I just appreciate you checking, Ms. Beatles. Thank you.
Okay. All right.
And so while Ms. Beatles is checking, I'll hand the baton to Hearing Examiner Ryan. If he has any questions for Mr. Malden.
Just one question for Mr. Malden. Mr. Malden, I think we heard in this case, I don't know if you were listening when Mr. Cervantes testified that, the economic principle, there's no free lunch, is always true. And that, in fact, the credit card payers pay fees that subsidize the ACH free payers. And that troubled me. And I'm wondering, did you hear that testimony?
Yes, I did.
Did that impact your analysis of this question at all? Something's happening in the background with loops. Ms. Beatles, I think that might be you. No, is she muted?
Nah.
I'm gonna mute everybody and there we go. Go ahead, Mr. Malden.
I don't recall seeing that in his testimony. written testimony, but I do recall it from his oral testimony. I don't think that it would affect my analysis because I feel like the $1.5 million allowance is reasonable. Just based on the known and measurable. And then I don't recall seeing anywhere in the cost of service any numbers that would or testimony that showed how the credit card payers are subsidizing the free ACH.
But you agreed, Mr. Cervantes said that.
Yes, he did.
Okay. That's all from me. Thank you, Mr. Malden.
Yep, thank you.
Staff, any redirect?
No, I do not have any redirect questions for Mr. Malden.
Okay, Mr. Malden, thank you for your testimony. We appreciate you, sir.
Well, thank you, guys.
Thank you. You're excused. Okay, well, we're in a little bit of limbo here. I do have a question for P&M regarding one of the bench requests. I've been trying to track down the filing of the response to bench request 9. And I do have before me the what appears to be the Excel spreadsheet with multiple pages of the computation of annual accrual rate as of December 31, 2021. Rates computed per bench request. That appears to be responsive. The title of the document is Exhibit 1, Accrual Rate Bench Request 9. And it says 6. Underscore, just the simple underscore. Well, that's for P&M response to BR2. I'm sorry. It said BR9, and then after the underscore, it says P&M response to BR2. So I thought that, at least in the Excel spreadsheet that hearing examiner Ryan helpfully prepared for us, he listed a bench request 9.
Yes.
Issued by Commissioner Aguilera.
Let me make sure I'm not getting my bench request confused. But I know there's one in the works today. Yes, the one in the works today that's being quality controlled, and then it should be ready to file early tomorrow. That's the next I have in my email inbox.
Terrific. And with that, I think that I have in my hard drive now, and P&M has filed all the other bench request responses and supplemental bench request responses. Is that right?
I
Mr.
believe that
Werger?
would be the case. I think this is the only outstanding one that took us a little longer to gather some data. So,
All right, I'm getting the parties advance notice. Tomorrow, at some point, we'll have some rulings on whether we're going to make evidence out of the bench request, not the response to bench request 1 regarding the SEM on rate credits. We're setting that aside, but we do have others that we need to look at and potentially make commission exhibits. And again, not commission AN exhibits. These will be separately marked commission exhibits 1 through whatever. One of them, and I know that there are some objections. We don't need to address it now because that would be premature. I'll go through the list, and those that we have marked commission exhibits, the hearing examiners will seek their admission tomorrow. But so that's just a heads up of what one of the items that the hearing examiners need to address tomorrow with the parties. And one of those bench requests and bench request responses relates to potentially the outstanding issue that PNM witness Sanders is going to address. So that one will come earlier in the day. And perhaps Gray, if the commissioners find it necessary to address that. We may have also, well, I don't know that we're going, I'm hopeful that we'll be able to finish tomorrow. I'm not entirely optimistic right now because of the amount of cross-examination we have left for the witnesses that remain to testify. So, Ms. Beatles, any word from Mr. Botts yet?
Not yet.
Mr. Gould, did you have something to address?
Yeah, just a very quick question. And this will probably reveal my total ignorance. Are all of these bench requests, have they been loaded up into Dropbox where I could take a look at them this evening? Just
I
to
believe
refresh
they-
my, okay. And is there a special tab?
Yeah.
Are they
Yes.
under the PNM tab or are they someplace else?
They're under bench under, we have 270, we have administrative notice, the prudence issue, and it's under the second sub-tab bench requests.
Okay, I'll find it then. Thank you.
And I think I just was going through that. I'll cross-check to make sure, cross-reference to make sure everything's there, but I believe it is.
I will do my homework then. Thank you. Appreciate it.
Sure.
Hearing examiner, I will say
Yes.
that from the best of my knowledge, I think generally PNM has less time than it has reserved for all of the witnesses who are left to be crossed. I know for at least the two that I'm crossing, I know I have less time than I have asked. So I guess if we can, if folks can all be available tomorrow, I think even though despite the reserved time, and unless there's a significant amount of questions from the bench, we might be able to progress quicker than what the schedule says. So anyway, I just wanted to give you that heads up.
Thank you. And that's promising, but a lot of it still is contingent on, how much we have to address tomorrow with Sanders and potentially Gray. And if there is any limited discrete cross-examination based on the testimony that is provided to the commission, right, from Sanders and or Gray.
Yes, Mr. Hearing Examiner, I might be getting ahead of ourselves, but I don't think we will have any. So we'll just see if we do, it'll be just one or two questions, but thank you.
Right, and I wanted to emphasize that I'm not foreclosing that opportunity. So I guess
Take our break.
Let's take a 15-minute break and come back and see. Well, actually, let's come back at 3:45. So about 20 minutes, and we'll see where we stand. I've addressed the housekeeping issues, but I'd like to take the opportunity to have Mr. Botts testify if he can find room in his schedule today. Okay,
And we'll go off the record, Mr. Lee, or if I just want to ask Mr. Madeira's
we're off
question.
the record. We're in recess.
Yeah, but if I understand, Crane, Reno, Kenny must be tomorrow. That's the idea.
And in that order, yes. And Ramey.
And Ramey. So there's nobody else we can call is the point. If we can't drum up Mr.
well-
Batts.
Well, we're talking about apparently 3 East Coast witnesses, and that was emphasized several times about Kenny and about Reno. And we know Ms. Crane is likely in Florida or potentially in Florida. I don't know where she is, but I believe that's her home base. We were told yesterday. So,
and Mr. Botts is in Maryland.
and he's in Maryland. So if he'd rather not testify because he's got conflicts, that's fine. But if he would rather testify today, this evening, Maryland time, that's his choice. We'll find out. And we may not find out, but we'll come back at 3:45. Okay, thank you. Well, we're not on the record yet. I noticed that Ms. Beatles, I just admitted, well, Sydney guessed. Ms. Beatles was already on, but I thought that was Sydney, but then there's Sydney guest that was admitted.
That's because I am having an issue with the broadband in my home.
Oh, okay.
Mm.
And in your car as well. Right.
Well,
It
it looks like since Ms. Beatles is in her car that it's unlikely that Mr. Botts is available to testify tonight.
We had the
So-
same issue where my co-counsel had to leave her one place and go to another.
Right. There's Ms. Beatles.
Well, I did, yeah, I'm sorry. Oh, he's on, he says he really can't today. You know, he
That's fine.
depended on, yeah, tomorrow or Monday, and he had scheduled other things, and he's still on calls. So I just got his text. I'm sorry.
No worries. He'll either testify tomorrow, hopefully, or Monday if we run into a problem finishing at a reasonable hour tomorrow night. We have a lot to accomplish tomorrow. We have, as I indicated before, the commission bench request that may want to be moved into evidence. We may have some discussion with commissioners about banding issues. I still haven't had a chance to address yet to fully understand what we may be doing there. You know, we'll have some further conversation maybe about the confidential advisory panel. And then obviously we'll be setting a briefing schedule. And if we're not able to accomplish everything tomorrow, then we may have to have a post-hearing conference on Monday or sometime next week to address those issues. But hopefully we can close the loops on most of these issues tomorrow. We can also do some of this through orders. So with that, Hearing Examiner Ryan, is there anything else that you'd like to address this evening or this
No.
afternoon?
No.
Okay. Then with
I have
that,
not gone on the I have not gone on the record yet.
let's go on the record now. Thank you. I'd like to go over the schedule of witnesses for tomorrow. We will start at 9 a.m. with P&M witness Sanders. Gray, Mr. Gray will be on standby. Then I think that the following that will be Ms. Crane for the Attorney General, Maureen Reno for Bernalillo County, Mr. Michael Kinney for CCAE, Mr. Botts for Western Resource Advocates, and Georgette Ramey for staff. And as I indicated just now in discussion off the record, we have some additional items to address tomorrow as we move to the conclusion of the hearing. Those issues being whether certain of the bench request responses that P&M has provided will be moved into evidence. We may have some discussion about concerns over banding, depending on what the revenue requirement ultimately arrived at in the case, whether the banding needs to be adjusted or we need further proposals on banding. That remains to be seen whether anything will be done on that issue at all, or whether, as in past cases, The hearing examiners have addressed the banding based on what was presented during the case and then the briefing that the parties provided. We also have the matter of the confidential panel and nominations for the confidential panel or the commission special advisors, which is also a term that has been used for that process, which is really post-decisional, post-recommended decision, meaning the hearing examiners provide their recommended decision to the special advisors who sign confidentiality agreements, and then they crunch the numbers and arrive at that, what I arrive at all the things that are required to execute the hearing examiner's recommended decision. That being the required revenue requirement, the cost of service, the reconciliation, all those exciting things.
Yes, and all the rate elements of the individual rates too. That's a tough assignment anyway.
That's a tough assignment, and we'll be soliciting nominations for a panel of what I envision to be 2, 3, or 4 individuals. One of them likely being Mr. Sanders, who will testify tomorrow morning. But that remains to be seen who the nominations are for the special advisory panel. So with that discussion, is there anything else to address this afternoon? There being nothing else to address at this point, we will be in recess until 9 a.m. tomorrow morning. Have a good evening, all. Thank you.
Thank you, Your Honor.